May I please your lordship? If consent taken from the opposite party lordship, consent taken from the opposite party lordship, I beg to mention item 51 lordship. I'm paying for today's accommodation lordship. Of supplementary list lordship. 51.
Learned counsel, on the prayer for learned counsel for the petitioner and with the consent of the other side. List the matter again on. Yes, when do you want?
After 2 weeks lordship. Obliged.
May I mention regarding item number 20 of today's list, okay? Here in this case diary was called for, probably that was not.
CD not received, my lord.
Right, item 20, CD not received, list again on.
My lord, interim is there, no?
No, it is not in this. Item 20 BA, he is in custody.
Oh, sorry. My lord, 6th.
Okay.
6th of May.
Obliged.
Well, I'm praying for adjournment of item number 41. Hearing matter, madam.
41.
No, no, second,
41, okay. On the prayer of the learned counsel for the petitioner, list the matter again on.
second week
When?
of June.
Huh?
Second week of June, madam.
We can make a motion.
Okay, sir.
Lord.
May I please your lordship? I beg to mention number 26. City was called for, but city.
26. Interim is there?
Yes, lordship.
Ready to continue till next day.
My lord, early fixed on, my lord, 19th of May.
My lord, I have appeared in item 16, my lord. This is a POCSO matter, my lord. We have taken steps upon the informant, my lord, but they haven't appeared, my lord. Any day in the next week, lordship, we will kindly fix it. 16, 16. 16, 16. Next week, my lord, any day. My lord.
Right, item number 16 on prayer of learned counsel, list again on.
May I please lordship?
Big man. And be on 5th of May, my lord, if possible. 5th of May, my lord. Yes, MDW.
May I please lordship? Lordship, I beg to mention item number 31, lordship. 31. Lordship, probably city is not received, lordship.
Received, my lord.
Well, they are the interim, lordship.
Interim is there, my lord, only fixed on 17th of May. My lord, 17th is holiday, 19th of May.
Obliged.
Maybe, lordship, I beg to mention item number 25. City is not available. Mr. Indian production is the
25, no?
25.
Interim?
Indian production may be continued. lordship.
Interim is there?
Yes, lordship.
Continue till next day.
18 May. 25, no?
Almost. 18 May.
Your Lordship, I beg to mention supplementary list 44, item number 44. 44.
Yes.
The engaged counsel is indisposed for a moment.
When do you want?
Kindly fix for the day for Friday.
This Friday is a holiday, I think.
Then Monday.
Next Monday. 44.
Supplementary list 40. Much obliged.
Lordship, I beg to mention item number 35.
Yes.
With the consent of the side, item of the
35, my lord, is tag with item 36 and 37. My lord, this matter may be,
Same person, different advocates.
this is of AB of 2018. He is an interim. My lord, let the item be called, serially, we have to look at, interim is there since 2018,
All
why the IB is connected,
Yes, you wait, let it come up, see. Yes, call up. You are
MS Salam.
the prayer of Mr. MS Alam Learned Counsel for the petitioner. The matter is dismissed as withdrawn.
May I please, your lordship? My lord, kindly call for the scan copy of the trial court reports, my lord. As because,
Seated.
my lord, as
Charge
because
sheet.
earlier occasion, my lord, only notice issued to listener two. So my prayer is that today, kindly call for the scan copy of the trial court report.
This case has been wrongly come in the motion column because in the earlier occasion also scan copy of TCR was called for.
I don't think it was called for.
My lord, I am appearing on behalf of.
Because Malaniphan is appearing for the.
Respondent number two. Lord Hart, you are Mr. S. Rahman.
Yes,
Rahman Learned Counsel for the additional and learned additional PP. Learned Counsel. Mr. So-and-so enters appearance for respondent number two. Call for the scan copy of the PCR. List the matter again on. 15. Right.
15
Police.
or number. What will I list?
May it please your lordship. Arrested on 4/2/26, 21/22 of the NDPS Act.
Commercial,
84 days.
commercial,
Commercial laws.
CD. In five. Item number three. Item number
15.
five. Five. Item number three.
May it please, your Honor. Here, FIR, your lordship will find at page 14. The petitioner is in custody, lordship, since 14/4/26. Page 14 is the FIR. As per FIR, lordship, so one abandoned bag was recovered by the police, where lordship, it was found 10 kg of beef meat, lordship. And on thereafter, these 6 persons were arrested, lordship, merely on suspicion, lordship. And nothing was recovered from the petitioner's, lordship.
It is required also.
And I have enclosed the seizure list, the forwarding report, all these things. Lordship will not find anything that any other material was recovered from these persons, lordship. Only that abandoned bag, lordship. And one bag, then 6 persons were arrested, lordship. How the other persons are connected, that is not there, lordship. In the forwarding report or in the seizure list or in the arrest memo, lordship. And 15 days, they are already in custody, lordship. And
Up
FIR,
to page 20, lordship, round of arrest. Round of arrest number 2, point number 2, lordship. The credible information has been collected during the course of investigation, established against the arrested accused persons of their active participation in an organized market engaged in illegal slaughter and smuggling of cattle within the jurisdiction of so and so persons. So let's.
Seventh, get CD, seventh.
can it be a short date, lordship?
How much shorter can we get?
Fifth, lordship.
Huh?
Fifth, lordship.
Where is this from?
Take time. 7th is.
All right. Item number four.
How long?
Lord, this originates from the same FIR, my lord. I am for the 3 accused, my lord.
All right. Same. Proceed.
Hey, please, your lordship. FIR is at page 17 and DPS case and recovered 35 kilo of ganja. Lordship.
So commercial.
Commercial.
Proceeding.
FSL maybe.
Hmm?
FSL report maybe. also.
City along with.
Has to be in the CD. I'm going to call for it separately.
Deeply.
Legal file.
Pardon? Deep.
Legal file.
11. Deeply.
Item number 6.
May I please, your lordship? Lordship, anticipatory bail, this is second item, lordship. Lordship. Earlier on rejected, lordship. Order is at 18, page 18, lordship. Lordship, the earlier bill was rejected, lordship, on the ground, lordship, at page 20, lordship. Para 6. On, lordship. Page 20.
No, sir.
Para 6, lordship.
Lordship, since earlier rejected, let us call for the up-to-date case study, Lordship, at this stage.
Lordship, he is the owner of the vehicle, lordship. Kindly, I may be protected, lordship.
Because
And lordship, on ground is there, lordship. Page 19, lordship.
whether stolen goods were recovered or not, that has to be ascertained, Lordship. For that, Lordship, up-to-date city is required.
Yes, CD.
Legal file.
Ticket,
11 file.
11.5.
Item number 7.
May it please your lordship, my lord. My lord, will kindly come to page number 10, my lord. The petitioner before your lordship is a candidate of Congress I party, my lord. There was a political clash between the two parties. And my lord, as usual, after election, normally, my lord, advocates are also busy defending people, my lord. He's a candidate, my lord, and the counting is on 4th.
Is the party still called Congress I,
Congress I. Yes, Congress.
not INC?
Indian National Congress, no, my lord. Colloquial language at times, my lord.
You are not colloquial. You are learned counsel.
Absolutely.
Yes.
CD, Lordship, at this stage.
My lord, he's counting, he need to appoint his political, no injury, nothing, my lord, these are all exaggeration. He was not, his pooling agents were not allowed to enter the pooling booth, my lord. And therefore, there was some altercation, nothing, my lord.
They're declaring the public servant while they are on.
These,
duty, Lordship, let us call for the case study.
because on 4th, my lord, he'll have to appoint his.
We would not likely presume that the electoral officer has falsely lodged an FIR.
Well, he'll
Nothing has happened.
have to appoint his polling agent on 4th is the counting, my lord. It may have an adverse effect on the electorate also, my lord.
Yes.
My lord, because these are not offences of that nature, my lord, that somebody is absconding, somebody has to be traced out. Because your lordship would be at liberty to reject it in case your lordship finds that something very extraordinary has happened, my lord.
Isn't that true of all cases?
That if something very extraordinary, if your lordship finds has happened, because there is no injury, nothing, my lord, these are all exaggeration. Because normally, my lord, during election time, there are allegations and counter allegation, it happens across the country.
I'm objecting at this stage, Lordship, because allegations are serious in nature. They have assaulted and used criminal force against the police, pulling personnel, and thereby deterring the
Your lordship, your
Public
lordship may
servant from the
consider the
purpose.
interim, I'll go and
Lordship,
get my
verdict may be
statement.
given, we will produce the case study and it will reveal everything.
My lord, I can understand because he belongs to the opposition party, maybe
Assault
therefore
was
maybe
there,
there is some
physical assault
objection.
upon public servant, lordship damaged and vandalized public property. This
These
is
are
clear
vague
allegations.
languages, my lord, public property, vandalism.
And lordship, one more thing, lordship, kindly come to page 11. Also mentioned that control unit of the EVM machine was partially damaged. So let us, city will reveal everything, lordship, because he is not behind the bar. It's an anticipatory bill.
My lord, I'll have to now appoint my pooling
Entry
agent
protection, at
counting.
this stage, I'm objecting, lordship.
My lord, she will object because he belongs to a party which is not, my lord, in power. So that is quite understandable.
This submission I am not expecting from a.
No, that
From a
is,
senior, such a senior.
no, I
advocate.
am not.
This is totally a
No.
personal attack.
No, I'm not.
This is
personal.
not fair. It's,
I'm
it's,
saying,
it's totally an unfair comment.
no.
Should be,
I'm not
It's not like
naming anybody.
we should ask for apologies.
Okay, I apologize.
That is not a correct statement. I belongs to a party, you belongs to a party.
I'm not saying.
I'm discharging my duty as a public
I'm not
court
saying-
officer, lordship, that's it.
Yes, but can you get it?
If any data as per the convenience of the court, lordship.
All right, fifth.
Highly obliged.
My lord, in the meantime, at least, because my lord, the counting is there, my lord. Had it been something otherwise, my
It
lord.
does
we
not
have
affect-
Thing is on EVM, you are not supposed to required to be there.
So, my lord, because I'll have to appoint the pooling agent and I'll have to be, my lord.
So go and
among the
appoint him right now.
Pardon?
Go and appoint him right now.
No, clearest bail application, my lord, the FIR in page number 9, my lord. The father of the girl has lost their own suspicion that the girl that his daughter has left with this person. In fact, my lord, his daughter went for a birthday party and did not return. Only on suspicion, he has lost the affair, my lord. And the girl has returned on the next day. What's in paragraph 6, I have stated, my lord. He went for a birthday party, sub-paragraph, my lord, near the GNRC hospital, North Gauhati, and then she have returned, my lord. Because father was suspecting they're having a relation, so on suspicion, FIR was lodged.
Lordship, the victim girl is to be recovered.
No, already recovered. Next day she returned, my lord. Paragraph 6, my lord, sub-paragraph 6. Next day she returned to the house, my lord. She attended a birthday party, did not return. Next day she returned.
And what happened in between?
My lord, she returned, my lord. There is no case. Only on enough. FIR is absolutely clear. On suspicion, father has lost an affair. Thus she has left with the boy. I'll go for the
It is
investigation.
possible that in the meantime, other sections may also get involved.
Lots will
after
give
recording
protection,
of
my
the
lord. I will
statement.
appear before I will cooperate with the investigation, my lord.
Right.
Only on suspicion, my lord.
CD.
In the meantime, lots will protect me, my lord, so that I can cooperate with the investigation, my lord.
It's possible that sections of the POCSO Act may have come in by now. After all, she was there with you for the night. Okay, on the next day, she has returned.
Item number 9.
Hey, please, your lordship. Lordship, the matter is ready for disposal. I think the impugned order is at page number 146. Lordship, it's ready for disposal, lordship. Can be taken. So the fact of the case here is that
This is against maintenance.
against maintenance, lordship, against 125 proceedings, which the honorable court has allowed in favor of the wife.
What is
No.
the amount?
Lordships, it was 10,000 per month, and there was also a child who was also allowed as a person to be maintained. So, lordship, collectively it was 10,000. And now, your lordships, the pertinent question which your lordship would be delving with
But here the provision of 125(4), for a moment, if I may take my lord, because there was a restitution proceeding filed by the husband, and section 9 of the proceeding, where I obtain an order in favor of myself as a husband, that a person who withdraws from the society of the husband, she is not entitled for maintenance. 125(4) takes note of that. This order I got in my favor. Subsequent to this, there was also a proceeding where she filed a 498 cruelty matter. That also she could not prove the fact of the case. So two of the matters went in my favor. Even in the proceedings of 125, the court arrived at a conclusion that though nothing has been proved, that is what the honorable court uses word, that nothing has been proved, in spite of that she will be entitled for maintenance. Now, for a moment, if I may take my lord at 125(4) of the CRPC, it makes very clear, lordship.
Yes, read.
And no wife shall be entitled to receive an allowance for the maintenance or interim maintenance and expenses of the proceeding, as the case may be, from her husband under this section, if she is living in adultery, or if, without any sufficient, she refuses to live with her husband, or if they are living separately by mutual consent. But if I am on the words which start with without any sufficient reason. Now, if my lord takes a page number 38, that is the restitution proceeding where this finding was, the honorable court had arrived at. Page 38, lordships. That is the judgment of the honorable court in restitution proceedings. It starts at page number 33. For my lord, the relevant page would be 38, lordships.
Yes.
Lordship, at page 33, the order is dated. Date of judgment is 12/4/2023.
Hmm.
Now, my lord, the relevant page is at page number 38, para 8.
Yes.
So considering all these aspects together with entirety, I am of the view that the opposite party has withdrawn herself from the society of the petitioner without any reasonable excuse, and as such the petitioner is entitled to get a degree of restitution of conjugal rights. In the result, the petition filed by the petitioner is allowed on contest by passing a decree of restitution of conjugal rights. The opposite party is hereby directed to join her conjugal right with the petitioner within 3 months from the date of the order. Now, my lord, will take the order passed by the impugned order, that is at page number 146. The court, though, took the note of this proceeding, in spite of that, it arrived at a conclusion note that there was some legal. My lord, the relevant portion, if I may invite my lord, at page number 55, that is in continuation of the said judgment. The impugned judgment, lord, page 55. 155, sorry, 155. Para 11, lordship. If I may read, lordship. Page 155, para 11. During the cross-examination of PW1, she admitted that on 6/9/2018, she went to her parental house to attend Narayan Puja there, and since then she had not returned to her matrimonial house. PW1 stated that she has not submitted any medical document before this court regarding her mental and physical harassment committed upon her by her in-laws and husband. PW1 further stated that she had not submitted any documentary evidence regarding her statement that her husband used to take ganja and he is a drug addict person. PW1 admitted to her husband had filed a suit of restitution of conjugal rights to bring her back to her matrimonial house. She further admitted that in the case, the learned principal judge, Family Court 1, Kamrup Metro, had given the order in favor of the petitioner, that is her husband. Moreover, in the cross-examination of PW2, she stated that she knows that the opposite party is a drug addict and has also seen him consume drugs. PW2 stated that she has not stated in her evidence on affidavit that she had seen the opposite party consuming drugs. She stated that the opposite party committed mental and physical harassment upon her daughter on a few occasions. Para 12. On the other hand, the opposite party in his evidence or affidavit as DW1 has stated that the true fact is that mainly due to the ill motive and behavior of the petitioner's wife, she came out from his company or conjugal life. However, he told her to come back within few days. While she failed to come or return to her matrimonial house, he approached her for several days, but she refuses to have a conjugal life with him. DW1 also stated that it is a matter of sorrow that even the parents of the petitioner wife asked him to be a Ghar Chowai, their own residence situated at this and this address. Further stated that it is quite impossible on his part to avoid his aged widow mother alone and live with the petitioner as Ghar Chowai. Finding no other option, he filed a suit or case for restitution of conjugal rights for taking her back in the court of the Learned Principles of Family Court, which was registered as FC this and this. And the same was adjudicated and decided in favor by the order dated 12/4/20, which your lordship has just read, directing the petitioner wife to enter or return to the conjugal life within 3 months from the date of DW. DW1 stated that the petitioner has a dirty hurt from which he did not get any peace, expected peace and comfortness. He stated that actually on 6/9/18, he, along with his wife, petitioner and minor daughter, went to the parental house of the petitioner on the occasion of Narayan Puja on her assurance to return after 2 days in the matrimonial home along with the child. But subsequently, he became reluctant to come with him in the matrimonial home, and even he visited his parental home after 3 days, and the petitioner father didn't allow her to come with him and told him to be a Gharjawar in their home. DW1 stated that the case filed against him has been charge sheeted before the Learned CGM Kamrup Metro Gauhati White PRC case number 1100/2022, and the Learned Chief Judicial Magistrate, by its order and judgment dated 19/1/24, gave acquittal to him and his mother and sister, holding the evidence of the petitioner is highly contradictory and doubtful, one, and fully unreliable. DW1 stated that the Learned Chief Judicial Magistrate in the judgment also came to the complete conclusion that there is no material to prosecute under 149(8)(a) of the IPC. DW2, that is the mother of the opposite party, has corroborated the evidence of DW1. During his cross-examination, the DW1 has admitted the petitioner's suggestion that he did not file any execution case after getting final judgment and order in FC this and this for restitution of the conjugal right. He further stated that the petitioner has been staying in the parental house since 6/9/18, and their child is at present aged about 8 years. He also stated that he has no knowledge where their child is studying at present, as he is not allowed to meet the child. DW1 has admitted that in Exhibit 2, it is not mentioned that there is no material to prosecute under Section 498 of the IPC. Moreover, the DW2 has stated in her cross-examination that the petitioner had been staying with her parental house since 6/9/2018. PW1 stated that she has not disclosed the source of receiving money in her bank account since last 3 years and has not submitted any voucher regarding her statement at point number 7 of column G of her affidavit of assets and liabilities. PW1 stated that she has not taken any gold ornaments with her parental house. Now, number 14 is the ultimate ratio of that judgment. Considering the materials on record, I am of the opinion that during the cross-examination of the petitioner, the opposite party had failed to contradict the evidence of the petitioner regarding her leaving the matrimonial home under compelling situations and staying with the minor child at her parental house. The act of, lordship, this is important. The act of the physical cruelty, though not proved, lordship, the word uses though not proved. The court herself arrived at a conclusion that it has not been proved. But the evidence on record clearly shows that the petitioner was subjected to mental cruelty by her husband, opposite party, in various forms. Now, lordship, 498, I already got an acquittal. There was nothing. No evidence. She admitted that I have not given any evidence in respect of these mental cruelty and physical cruelty. The grounds of mental cruelty gave sufficient reason for the petitioner to leave her matrimonial. From the totality of the evidence of both the parties, it appears that the petitioner has been able to show that she left the matrimonial home under compulsion only and took shelter in her parental house. Thus, I held that the wife has left the matrimonial house under compulsion. Now, if my lords take up the cross-examination of the wife, Yes, Lordships, page 44, Lordship, that is the cross-examination of the wife. Annexure 3, Lordship.
Yes.
Lordship, at para number 2, if I may read, Lordship. Para 2, Lordships. It is not a fact that on 6/9/2018, my mother went to the house of the opposite party. It is not a fact that I have falsely stated that on 6/9/18, my husband had beaten me up. Lordship, this is important. It is a fact that on 6/9/18, I went to my parental house to attend Narayan Puja there. And since then, I have not returned to my matrimonial house. And Lordship, this has been settled in the judgment as well, that she admitted that she herself has left the society of the husband.
Yes.
And then, my lords, at page 122, that is the judgment of the PRC case 1100, the proceeding of 498A. Lordship, at page 122. If I may read, Lordship. This is order dated 19/1/2024. All the accused person, namely this and this, are present with their learned counsel. Today is fixed for judgment. Judgment is ready and typed on separate sheet and pronounced in the open court. It is appended to the case records. In light of the evidence led by the witness and the decision has arrived at and mentioned in the detailed judgment, it can safely be presumed that the prosecution has failed to drive home the guilt of the accused person beyond reasonable doubt. Hence, it is held that the prosecution has failed to convict the accused person and are acquitted of all charges under section 498 IPC and set liberty forthwith. Lords will kindly have page number 128, Lordships. There, Lordship, they have contradicted even the date of saying that on which day they have left the matrimonial house of hers. Lordship, at 128, para number 6, Lordship. Page 128, Lordships. Para 6, if I may read, Lordships. PW1 is Srimati Navami Sharma, who in her evidence deposed that she is the informant of the present and she had filed the case against her husband Dhanjit Sharma, her mother-in-law Naukani Devi, and her sister-in-law Puravi Sharma. She was married to the accused Dhanjit on 22/2/2016, and for around 1 week the marriage went off well. However, the other accused person instigated her husband and stated mental harassing her over trifling matters. If she called her mother and out others back home, her husband used to break her mobile phone. They also have one daughter from the marriage, and after her birth, all the three accused persons started her and her sister-in-law and used to pull her by her hair. Lots of this date. On 10/10/2017, while he was trying to awaken her husband from sleep, he threatened to cut her into pieces and abuse her, and also called her father over phone and threatened to kill her. Unable to face the same, she came home that day itself. Lordships, here she says that I left my home on this date, whereas the other document says 6/9/2018. So she contradicts everything, Lordship. And my lord, may my lord take my lord at
What
peace.
was the date said earlier?
Lordships,
What was the date of leaving according to her evidence earlier?
6/9/2018. Just a moment, Lordship. I'll take your Lordship to the evidence. That is at page 44, 6/9/2018. At page number 44, para number 2, she admits that she went to the parental house on that day when her mother came to take her. And now here she says that that date is 10/10/2017. Because this FR was given prior in point of time. Later on, she came up with this plea, Lordship. So she was changing her stand, and that was also the finding of the PRC case, the court said that yes, there are much more contradictions in her statements. So therefore the acquittal was given to us on that count as well. Lordship, page 129, if for a moment, if I may take my lord. Lordships. From the first line, Lordship, where it starts from, she has not mentioned any specific date in the FIR, as my lord got. So now the second line, Lordship. From the top, Lordship. She has not mentioned any specific date in the FIR. She has not mentioned in the FIR the specific date and time when her husband started assaulting her and abusing her. Her husband used to work as a supervisor at GMCH. She knows that the accused was working in a contractual capacity and his contractual job was terminated. As her husband lost his job and he could not provide her with the due care and provide her with basic necessities, their relationship turned bad. She denied the defense suggestion that as her husband lost the job and he could not provide her with care and provide her with her necessities, she went home and filed the FIR. At the time of the FIR, she was in her mother's home. On 21/11/2018, the FIR is seen to have been filed. No such incident took place on that day. There the court came to a finding that she does not even make out a case for conviction. Nothing was proved. Not a single material of mental cruelty, physical cruelty, nothing was there. And in fact, my lords, the witnesses who were there, Lordship, they refused to say that, Lordship, that no, we don't know about the matter as well. That is a
discussion of the evidence. This is not finding.
Lordship, it's a finding. This matter has been resolved. Lordship, the acquittal is at page.
No, we know that, but what you are reading at page 29,
Lordship,
that is discussion of the evidence.
discussion of the evidence. Then, Lordship, at 130, page 130, the other evidences who were present to corroborate her. Lordship, they said that we are not aware of these facts. Why are we called? We don't know. At page number 130, PW2, who in her evidence reports that she knows the informant of the present and she also knows the accused, Dhanjit, who is her husband. They live near the house. They do not live together now. She doesn't know anything about the case and why she has been arraigned as a witness.
All right, we need not go to all that because that case is already decided.
Means the Lordships. And if I may take my lords at page 123, lords, it will show the date when the offense is said to have occurred and when the FIR was filed. Lordship, at 123, date of the offense is
123,
Lordship. After 2 years of the offense, this FIR was allegedly filed. Lordship. Date of offense 22/2016. Date of FIR is 21/11/2018.
yes.
So, Lordship, in view of what, Lordship, that 125 says that without reasonable excuse, if she leaves the matrimonial house of the husband, she is not entitled for maintenance because the judgment of the conjugal right came prior in point of time. Then the cruelty case was filed, a false case of cruelty was filed. There also I got an acquittal. But this court held that though not proved, Lordship, the word is very important because if nothing has been proved, the order ought to have been that mental cruelty has not been subjected to because there is a concurrent finding of 2 other courts as well. So that is my respectful submission.
Yes.
Firstly, my lord, regarding the date of offense, my lord, in the FIR, just now the Malayan council has pointed out, but that is the one date of marriage, 22/2/2016, my lord. However, it must have been written due to some mistake, my lord. Well, when you want to understand this case, my lord, lordship had to understand the circumstances, my lord, that the wife has to face, my lord, before she left the company of the husband, my lord. What happened, my lord, after her marriage, my lord? She was expecting a very happy married life, my lord. But due to the constant, my lord, bad habits of the husband, my lord,
He was, my lord, in the habit of, my lord, drinking every day, my lord. And also he was in the habit of taking, my lord, intoxicating substance, my lord. Due to which, my lord, he used to come home very late, my lord, and he used to abuse the wife, my lord.
What is the evidence in this regard?
My lord, she had already, my lord, stated this in her petition, my lord, which your lordship will find, my lord, in the maintenance case, my lord, from page 21, my lord.
What is the finding of the court in this regard?
Well, the finding of the court is that, my lord, she has not produced any, my lord, documentary evidence, my lord. Documentary evidence of mental torture, it is very, my lord, difficult. It can only be proved by the evidence of someone who is present in the house, my lord. And documentary evidence of,
You
my
are not
lord,
challenging that order.
my lord,
You are not challenging that order.
my lord,
So what is the finding
the
regarding
fact of the case.
what
my
you
lord,
are submitting? Because we are not going to decide whether he was drinking or smoking.
No, my lord.
We want to see what is the evidence there.
Well, evidence, my lord. What happened, my lord? Initially, my lord, husband has, my lord, he has filed a case for restitution, my lord. In that case, my lord, she had appeared initially and filed her written statement, my lord. After filing her written statement, my lord, she ceased to appear, my lord, in the case, my lord. And the case proceeded ex parte, my lord, and ex parte judgment was passed, my lord, which your lordship will find, my lord.
Now, we have seen that.
Thereafter, my lord, what happened, my lord? She filed this case for maintenance, my lord. What happened, my lord? Unable to bear his, my lord, constant torture and physical and mental torture, my lord, she left the house of the husband, my lord, and started living with her mother, my lord. That happened, my lord, on 6/9/2018, my lord. And thereafter, my lord, after around 2 months, my lord, she filed this FIR, my lord, against the, my lord, husband, his mother, and, my lord, sister-in-law, my lord. And subsequently, my lord, she filed a case for maintenance, my lord. And in that maintenance case, my lord, the honorable court has rightly held, my lord. I will just like to place reliance on the judgment of the honorable court, my lord. Only ground, my lord, of the husband, my lord, for not that she left because, my lord, she wanted him to get hot. That is the only issue of the husband, my lord. And he has not stated anything else, my lord. That the girl and her, my lord, family, my lord, wanted him to be got joy, my lord, due to which, my lord, there was conflict in the house, which is not true, my lord. She was compelled to leave the house, my lord, because of the bad habits of the husband. He was constantly in the habit of drinking and taking intoxicating substance, my lord. Moreover, my lord, he was also used to.
See, let us narrow down the issues.
My lord.
You need not submit on facts what she happened, what she did, what he did. We are not here to determine that now. That is for the trial court. Now, trial court has come to the finding that she was subjected to mental harassment by the petitioner. So we are only to see whether that finding suffers from perversity, number one. And number two, what is the effect of the judgment of the courts in the application for restitution of conjugal rights? How far are those findings applicable in the 125 maintenance proceedings? These are the only two issues.
Restitution of conjugal right and, my lord, maintenance proceeding, my lord. These two are separate proceedings, my lord. If the restitution of conjugal rights, if the husband had a judgment on the restitution for conjugal rights, my lord, and the wife did not, my lord, come back to the house of the husband and lived with her, my lord, then what would, my lord, entail, my lord? He should have gone for, my lord, execution of that restitution proceedings, my lord. But he has not done that, my lord.
How is the restitution proceeding executed?
Execution, my lord. For execution of this, my lord, by forcing the wife to come back and live with her husband, my lord.
Where is it laid down?
My lord, that would, my lord.
But how can I force somebody who doesn't want to
Will
come?
the police
That
go
is
and
what
bring
we
her
should-
back?
Or my lord, neither he has, my lord, he has not even filed for divorce, my lord. Because this restitution proceeding was not, my lord, restitution judgment was not, my lord. The wife
Does the
failed
law
to,
say
my
he
lord.
must file for divorce?
Yes, that is what my brother is suggesting.
There may be many reasons why he may not file for divorce. His child is there.
Child is there, Lordship.
My lord, my humble submission is that, my lord, these two are, my lord, separate proceeding, my lord. And I'd like to place reliance on, my lord, on a judgment of the Supreme Court, my lord, in a very similar case, my lord. Reported in, my lord, 2025 3 SCC 33, my lord. Reena Kumari versus, my lord, Dinesh Kumar Mahato, my lord. Here, my lord, your lordship will find, my lord. First page, my lord. Maintenance, refusal to pay, mere passing of decree for restitution of conjugal rights at
Where are-
husband. My lord, in the first page, my lord, under A, my lord. Mere passing of a decree for restitution of conjugal rights at husband behest and non-compliance therewith by wife would not by itself be sufficient to attract disqualification under section 124 CRPC. It would depend on facts of individual case and it would have to be decided on strength of material and evidence available. Whether wife still had valid and sufficient reason to refuse to live with her husband despite such decree. There can be no hard and fast rule in this regard, and it must invariably depend on distinctive facts and circumstances obtaining in each particular cases. Decree for restitution of conjugal rights secured by husband coupled with non-compliance therewith by wife would not be determinative straightway either to her right to maintenance or applicability of disqualification under section 125(4) of CRPC. Then, my lord, under B, my lord, refusal by wife to abide by decree for restitution of conjugal rights secured by husband. Two proceedings are altogether independent and are not directly or even indirectly connected, in the sense that proceeding under section 125 CRPC do not arise from proceeding for restitution of conjugal right. Standard of proof in civil proceeding is preponderance of probabilities, whereas in criminal prosecution, conviction requires proof beyond reasonable doubt. Such principle cannot be applied per se to proceedings for maintenance under section 125 CRPC by relying upon judgment passed by civil court on application for restitution of conjugal right. Considering
Yes,
behavior
that
of
is-
husband.
That is why we asked point number 2. Point number 1 is whether the judgment under challenge suffers from any perversity. Point number 2 is whether that other judgment, how far it is applicable in the present case. So Supreme Court says that is not determinative. Finding of the restitution that is not directly applicable.
Directly applicable in the maintenance proceeding.
So that part is over. Now we are only to see whether the findings of the learned family court suffers from any irregularity, perversity.
For a
etc.
moment, if I may draw my lord's attention, the judgment which my learned brother is referring, para 38 of the SCC volume, page 50 of the judgment, particularly the facts that the witness who appeared on behalf of Reena's lordship, the petitioner in this matter,
Which paragraph? 50.
Paragraph 38, lordship, in the SCC volume. Lordship, in my paragraph, it is 38. This is SCC citation, lordship. So it starts with the word viewed thus, the finding. Maybe minutes from the last 2 pages somewhere, lordship.
Viewed thus.
Viewed thus, lordship.
Okay, para 35.
Absolutely. The finding in the proceeding, if I may read, lordship. The finding in the proceedings for restitution of conjugal rights, which were partly uncontested, as Reena did not appear before the family court to adduce evidence or advance her case after filing a written statement, did not clinch the issue, and the High Court ought not to have given such undue weightage to the said judgment and the finding therein. In the process, certain crucial factors were overlooked, particularly the fact that the witness who appeared on behalf of Reena in section 125 CRPC proceedings were not even cross-examined. It was clear therefrom that Dinesh did not even contest it or rebut what they had stated. The fact that Reena was fully dependent on her brother was thus admitted. Further documents were placed on record in proof of Reena's abortion on January 2015. In that regard, Dinesh's admission that He did not bear the expenditure for her treatment, and her unrefuted assertion that he did not take her to the hospital or even come from Ranchi to see her were clear indication of the pain and mental cruelty meted out to her. The fact that she was not allowed to use a toilet in the house and avail proper facilities to cook food in the matrimonial home, facts which were accepted in the restitution proceedings, are further indication of her ill treatment. But in my fact, well, not a single item of evidence to that effect that mental cruelty she was subjected. Well, that takes the matter to a different angle. Here, Mullard, the court says that nothing has been proved. And Mullard, the husband in
Nothing has been proved with regard to physical
physical and
cruelty.
Lordship, that is what-
Mental cruelty, court's finding is that it is proved.
Lordship, here the court says that ill treatment was there in the restitution, 125 CRPC proceeding. In my case, Mullard, nothing has been proved. The court itself says, though nothing has been proved.
No, though nothing has been proved with regard to physical cruelty.
Physical cruelty, Lordship.
But mental cruelty is proved, court
The
says.
court says, Lordship. That
Yes.
is what the court says.
So what is the perversity in that
finding-
finding? What is the irregularity in that finding?
So, Mullard,
That is what you were supposed to show.
so far as Mullard, the concomitant issue of that restitution proceeding that she has herself withdrawn. And Mullard, the evidence she admits that she left the company of the husband. In my respectful submission, Mullard, that would suffice the cause of 125(4), Lordship. That without reasonable excuse she has left the company.
All right.
Lordship. I'm so obliged, Lordship. And Lords, two of the queries which my learned brother have raised, if I may reply, subject to my lords.
Yes.
But it page 139, Lord, he has raised an issue that he was in an intoxication. Lordship may have page 139 for a moment, Lordship. Lord, I'll take it precisely, Lordship. Page 139, Lordship. Para number 2, Lordship. I had not stated in my evidence on affidavit that I had seen the opposite party consuming drugs. This is PW2. She earlier said that she had. Para 2, Lordships. Para number 2, I had not stated in my evidence on affidavit that I had seen the opposite party consuming drugs. Lordship, the issue goes here also. That never seen, what is the issue of saying that he has been intoxicated? And now, Lord, at page 35. Para 2. But my brother has read that matter went ex parte. Page 35, Lordships. Page 35. Lordship. That is the restitution matter. At page number, para number 2, the court, Lordships, has, my lord has got para number 2, Lordship. The opposite party, however, entered into an appearance and contested the case by filing written statement.
No contested. And file written statement.
Lordship,
Contested.
she contested. He said that the matter went
That
ex
is what I have
parte.
already stated. She filed her written statement, but thereafter she chose to appear, madam.
And she was very well aware of the proceeding and she never challenged this proceeding. In fact, it was a finding of the letter tribunal, this remains as well. Lordship. That has attained finally.
Yes.
And my lords, one important aspect, my lord, I draw my lord's attention at section 13 of the divorce of the Hindu Marriage Act 1955. Now there is an amendment, my lords, at 1A under the divorce, my lord, in case of cruelty of granting a divorce, section 13 divorce.
HMA section.
13, lordships. 13, 1A, 1A, lordships, 1A, capital A, subclause 2. That, this is one of the grounds of divorce. Any marriage solemnized whether before or after the commencement of this act may, on a petition presented by either the party of the wife, be dissolved by a decree of divorce on the ground that the other party, let's say 1A, subclause 2 says, that there has been no restitution of conjugal rights as between the parties to the marriage for a period of 1 year or upwards after the passing of a decree for restitution of conjugal rights in a proceeding to which they are parties. So this becomes a ground of cruelty as well in respect of the husband.
Those are matters of
No, that
final
is the matter of-
adjudication for the
absolutely.
purpose of maintenance that would.
Correct. I just wanted to my lord's attention, that becomes a problem. One knows it very well, the false filing of cases under 498 is also a cruelty upon the husband. That is what.
All right, save it.
And so pleasure, deep pleasure.
In months.
Pleasure.
Number 10.
No, this revision has been filed against the impugned order, lawsuit find page 46. By the impugned order, this is the annulled case, my lord. And on the ground of some delay, the London Trial Court has rejected the complaint petition by impugned order dated page 46 is the order, madam. 21/11/24. Relevant portion you will find page 48, page 48. Where is the delay is explained, and it is only 15 days delay. And there is provision for condonation of delay under section 142 clause 1B. And
You're reading page 48.
48.
Para, which para? Top.
Lordship will find para 1 to 3. Accordingly, the complainant issued.
Yes.
Lordship got middle
Yes,
person.
yes, yes.
On 26th, notice was issued on 26/3/18. And from the date of receipt of the notice was received on the notice was received on 28/3/18. And after that, within 30 days, complaint is to be filed. So according to the court also, there is delay of 15 days. Payment of check amount within 15 days of the receipt of the notice. But thereafter, hence counting 15 days from the date of receipt of the demand notice by the accused, ends on 12/4/18. Cause of action arose on 12/4/18, which runs for 1 month as provision under section 142 clause 1B. Such complaint is made within 1 month of the date on which the cause of action arises under clause C of the provision of section 138. And the limitation period expires on 12/5/18, my lord. And the petitioner filed the petition, complaint petition admittedly on 27/5/18. So 12/5, 27/5, it is 15 days delay, man. So under the provision of section, I'm reading it is a very, my lord, on this limitation point only, my lord. I'm reading the section 142(1)(b) of the NI Act, my lord. Thus, you will find that there is specific provision regarding condonation of delay. But the learned trial court did not consider this provision. NI Act, your lordship. Section B is that, my lord, the provided that the cognizance of a complaint may be taken by the court after the prescribed period, if the complainant satisfied the court that he had sufficient cause for not making a complaint within such period, my lord. So in the complaint petition, I explained that the delay was made due to medical ground, my lord. complainant was suffering from his backache and he could not run from his house to the event to the court, man. So he could not. Thereafter, medical certificate was also proved, what was exhibited, that was not considered. Only on the ground that that is not sufficient proof.
Where is the certificate? Have you annexed it?
Yes, madam. Certificate I annexed, madam.
Where?
Loss you will find at page, medical certificate. And check D series, madam. Page 41 to 50. This one is page 38, page 38. Sorry, ma'am, page 38. This is the type copy and the certificate is, my lord, page 38A. This is by certified that Sri Milan Palit, aged about 9 years, was suffering from lower backache and was under my treatment from 7/5/18 to 25/5/18, my lord. And he was advised complete bed rest during said period treatment. He is now fit to resume the activities, my lord. So the learned trial court held that the on 25/5, he up to 25/5, he was advised to take rest. So he should have filed it on 25. And after 2 days, he has contacted his advocate and filed that, my lord. So that is admittedly that, my lord,
When did you file?
27, my lord.
So up to 25 is your bed rest period.
Yes, my lord. After 25, only after 2 days, I filed, my lord. Filed on 27/5/18. So, my lord, it's a simple matter, my lord. So, your lordship may remand the matter, considering considering the delay of this period, my lord, because it is a check of, admittedly, check was given of 5 lakhs, my lord. And what happened, my lord, interestingly, the opposite party appeared before the trial court and also did not file any written objection on this, my lord. And on the day of judgment, also hearing, they were not present. And in the before this court also, they are evading, my lord. And amicus curiae was happened.
Yes, amicus.
Lordship. Lordship. Lordship, my humble submission is that regarding the medical certificate, just a bit of confusion. Lord. There has been no prescription as such. Only just a copy of the medical officer. This is my humble submission before the Lordship. Delay, Lordship, it's not that much.
So in the complaint petition, delay was sufficiently explained in para 13 and 14. Now, my lord, only on my lord, limitation ground, no hearing was made on merit, my lord, whether the court has ample power to consider it.
Learned counsel for Mr. So-and-so, learned counsel for the petitioner, and Mrs. So-and-so, learned amicus curiae. Para although notice was issued and served upon the sole respondent, none appeared on her behalf. Accordingly, learned amicus was appointed to represent the respondent. Full stop. The petitioner is aggrieved by the impugned order passed by the learned JMFC Kamrup Metro, whereby impugned order dated 27/11/24 in CR number 3341 of 2018, whereby the learned magistrate refused to take cognizance of the complaint filed by the petitioner under section 139 of the 138 of the NI Act. In view of its finding that the complainant failed to file the complaint petition within the period prescribed under section 142 of the NI Act, and accordingly dismissed the complaint. According to the complainant stroke petitioner, the respondent accused had issued a check for an amount of rupees 5,50,000 to the petitioner, which was dishonored, and therefore the complainant stroke petitioner had to make a demand for payment of the check by giving a notice in writing to the accused within 30 days of the receipt of the information by him from the bank regarding the return of the check as unpaid. Full stop. Then go to page 48 from the third para. The reason for delay in referring the complaint was explained by the complainant as being due to medical reasons, inasmuch as the complainant petitioner suffered from backache, and the doctor had advised him for complete bed rest from 07/05/2018 to 25/05/2018, observing that there was a likelihood of aggravation of his backache. Full stop. It is for this reason that the complainant stroke petitioner could not contact his engaged advocate to file the complaint within the period of limitation. Full stop. In support of his contention, the petitioner submitted a certificate issued by his doctor on 26/05/2018, wherein it was mentioned that the complainant stroke petitioner was suffering from backache and was under his treatment from 07/05/2018 to 25/05/2018, and that he was advised complete bed rest during this period. Full stop. The complainant stroke petitioner filed the complaint petition within 2 days after completion of the bed rest period. That is on 27/05/2018. And therefore, it is submitted that there was no inordinate delay on the part of the complainant petitioner in preferring the complaint, and the actual delay, if any, is only of 15 days.
Lots.
Full stop. A perusal of the impugned order would indicate that the learned magistrate doubted the authenticity of the certificate since it was issued on 26/05/2018. That is 1 day after the expiry of the period of bed rest. And also took into consideration the fact that no prescription or advice slip of the doctor was submitted by the complainant. Nor any other document, nor submitted any other document to show that he was under the treatment of the doctor who issued the certificate. Full stop. The certificate, which was certificate issued by the doctor dated 26/05/2018, which has been annexed to the complaint petition, has been issued immediately 1 day after completion of the period of bed rest. It is not expected, not logical to expect that the doctor would issue a certificate regarding the period of treatment even before the same is over. And it is quite in the order of things that after the period of treatment stroke bed rest is over, a patient would obtain a certificate from the doctor for any purpose for which such a certificate may be required. Full stop. It may not always be necessary for a patient to obtain such a certificate if one was not required for any purpose. Full stop. Prima facie, therefore, there appears to be no reason to doubt the authenticity of the certificate, as at the time of considering a application, considering the question of condonation of delay, it is not necessary to go too deep into the matter. Full stop. Only prima facie satisfaction is required. Full stop. Further, when such a certificate has been presented by the complainant, it would be excessive to insist upon further documents, particularly keeping in view the length of the delay of only 15 days. Full stop. Having regard to the aforesaid facts, I am of the view that in the interest of justice, the impugned order requires to be interfered with. Consequently, it is held that the complainant has sufficiently explained the delay in preferring the complaint petition. And accordingly, the impugned order dated 27/11/24 passed by the learned JFMC Kamrup in CR number so and so is set aside. And the matter is remanded to the learned trial court for taking a fresh decision with regard to cognizance, by considering the delay to have been sufficiently explained and condoned. Also, the revision stands allowed accordingly.
God bless.
But in this case, I pray for short accommodation, Miller.
Used to be listed in the hearing column anyway. Last order was that.
Correct, Miller, but
Any TCR?
TCR received.
TCR received.
Day after tomorrow, Miller,
Day after tomorrow.
or any date as per your lordship's convenience.
What is the matter about?
But matter pertains to, Miller, the framing of charges against the accused person, Miller. The learned trial court, Miller,
11. Yes, I'll give it.
there are two IAS file altogether, Miller, along with this criminal revision petition.
IA4?
One is for condemnation of delay, it was condoned, Milord. Another was for, Milord, grant of bail.
That is pending.
My lord, that is pending.
So we have to hear the matter
Both-
finally.
Both the missed cases are disposed of, Milord. Yes,
Bail is also disposed of.
yes, that is also disposed of.
So
To
matter-
our information, Milord, the bail has been granted from the learned court below. Now, the revision petition is fixed for hearing, Milord. Today, I have some difficulties, Milord, because
This
day after
matter
tomorrow.
was expected to be listed for hearing. However, it has been listed in the admission column today. Around the prayer of learned counsel for the petitioner, list the matter for hearing on. And expect that the detail. Oh. 7/5.
7/5. I am deeply obliged.
Number 12.
Lordship, here in this case, as per noted of flag A, I had filed my rectified IA, whereby the correct section at page 82, my lord, 397/401 CRPC, read with section 482, along with 430 and 442 of BNSS 2023. My humble prayer is that since the condonation delay has been condoned by this honorable court, so Lordship may grant me to issue notice to the.
Why was it, why additional affidavit was filed to correction of something?
Yes, correction of the section for the application, because since it is under IPC, the judgment which has been passed, this honorable court point out to rectify. And accordingly, as per direction of this honorable court, I had rectified. Page 82, paragraph 3.
No, correction of the section.
You have made so many corrections by hand and
Lordship, it is, since it has been defective for last long, then accordingly it has been done. I may be allowed to quickly issue notice, Your Lordship, because it is a conviction
no,
for 1
even,
year.
even now I am not able to follow. If you've got a copy of the additional affidavit,
Copy for anything.
see, you say it is observed that since the alleged crime
Lordship,
arose prior to the coming into force of the BNSS,
Lordship,
the applicable procedure law would be the BNSS.
Lordship. It should be IPC. That is a rectification I have done a very short.
No,
time.
what rectification have you done? This is your rectification, isn't it?
Lord,
Page 82.
Lordship. Section 397-401 CRPC, read it section 482 CRPC, and instead of 438.
What is the date of occurrence?
My lord, the date is occurrence on 20, judgment has been passed on
Yes, date of offense is 24/7/2018.
18, Your Lordship.
And that is
And,
prior to.
prior to,
And prior to then it should be CRPC.
it should be CRPC.
Then
sir.
you have written in your additional affidavit itself. So what was it? What have you corrected?
I had corrected, Your Lordship, section 397 and 401 CRPC. Read it section 482 of CRPC 1973.
No, you have written it the other way. If it is different in your application, I don't know, page 82, show it.
So,
Show it to PP also. First paragraph, top paragraph, he says it is prior to, and then say it should be under.
2018,
it
Lordship.
ought to be a Lordship, CRPC.
What places you have written BNSS only?
Let me, it is my mistake, inadvertently mistake I done my. Let me take a face with a short date, Your Lordship.
On the prayer of learned counsel for the petitioner, list the matter again after a week, give it.
It may be fixed, Your Lordship, with lots of hands. So long. Deeply.
He is hearing BA, item number 13.
May it please your lordship. Regular bail application, lordship. The POCSO is there, lordship. And the petitioner is behind the bar since 26/6/2024.
Which section?
Section lordship 10. Till today, lordship 671 days. Because my main ground is the lordship non-compliance of lordship section 50 and 50 of the CRPC. Violation, lordship, and there another ground, lordship, is that the co-accused persons have been granted bail who were charged with under section 6 of the POCSO.
And what is the allegation basically?
Basically, allegation, lordship, informant is the wife, is my wife, lordship. Allegation is that, lordship, her son from the earlier, her daughter from the earlier marriage was subjected to lordship sexual assault by me, by my son from earlier marriage. My two sons, lordship. That is her step brother, lordship.
Husband.
And I am, lordship, her stepfather. Page number 14, lordship, may kindly see. Page 14.
This is under section 4.
This was registered under section 4, grade 376 3 CRPC, IPC. Then the charge sheet was filed under lordship 376 3, read with section 6 of the POCSO Act in terms of the my two sons, lordship, and against me under section lordship 10 of the POCSO Act. Lordship, may kindly see page number 19 for a moment.
Against you means who are you? Harinath Gogoi.
I am the father, Numal Gogoi.
Numal Gogoi.
Numal Gogoi. Page 19, lordship, may kindly see. Charge framing order, lordship. Page 19. Then lordship, may kindly see third para, heard both sides on the point of charge. Consider the case record along with all the relevant documents. After such hearing and consideration, this court is of opinion, considered opinion that there are sufficient grounds for presuming that the accused Boikunda Gogoi and Harinath Gogoi, they are my son, lordship, have committed offense punishable under section 6 of the POCSO Act, read with section 376(3) IPC. Then, lordship, last part, separate charge under section 10 of the POCSO Act is framed against the accused Numal Gogoi. Numal Gogoi is the present petitioner, lordship. Only
Yes.
section 3.
The POCSO matter, lordship, but not other side.
But other side has appeared or what?
No, lordship, not reflected in the cause list.
And office note, my lord, on 22/4/2026, steps taken, my lord.
It appears that as per office note, steps were taken only on respondent number 2, only on 22.
না আপনালোকে পুলিশ
আমাক পঠালে আমাক পঠাব লাগিব
426. Hence, I with service on respondent number 2.
lordship, as per the notification, lordship, we will sub copy to the PP, lordship, he will do the
Yes.
needful.
They have to take the registry forwarded to us, my lord.
Yes,
Then we
that is the
forward it.
process. You have to file registry will forward to them.
When it is fixed, lordship? Fixed.
Fix on.
6/5. 6/5. Much obliged, your lord. Much of.
Item number 15.
6/5.
Item number 15 and 18, my lord, in both the cases, searches submitted, my lord.
PCR will be required, lordship.
Is here. But it is submitted, the charge sheet has been submitted by CS number.
Section number 43/2026, dated 27/4/2026.
Hence, call for the scan copy of the TCR list again.
Five.
7. Deeply obliged.
Item number 17.
May I please, your lordship? Lordship, the allegation cease of POCSO, lordship, and behind the bar 57 days. This is the substituted case, lordship.
My lord, we have filed an objection. It has not come in this record. I have. So let it come on a Monday, my lord.
All right. Heard learned counsel for the petitioner, learned counsel appearing for respondent number 2 submits that an objection has been filed which is not on record. Registry is directed to place the same on record and list the matter again on 4/5.
Obliged.
Item number 18.
My lord,
At 2 PM, my lord. Senior is another court, my lord.
18 is similar to item number 15, succeeded yesterday. My lord, in this case, on the first day of 6/4, wrongly, my lord, actually, my lord, TCR has been called. At that point of time, it was not succeeded. Today, I have checked them the TCR, only the CD part, because succeeded yesterday only CD has come. In 15, my lord already called the TCR, fixing on.
Same case.
Same case, fixing my lord on 11/5. So, my lord, TCR may be called for, TCR of the,
TCR is called for in that case.
TCR call, they have come on the CD part, because it was
No, no,
not
no, in
succeeded.
15.
15, no, look, 15, today we got that succeed submitted, my lord. TCR perhaps call and fix on,
15
my
of
lord.
TCR call has been called for. So same case.
Same case, my lord.
All right. It is heard learned counsel for the petitioner and learned additional PP who submits that the present case is connected to bail application 598 of 2026, wherein the scanned copy of TCR has been called for fixing the next date on 11/5, hence list the present matter again on 11/5, along with the bail application number 598 of 2026.
Highly objection. 19.
In this case, TCR has not been received.
Service also awaited, lordship.
All right, TCR not received. Service on respondent number 2 also not complete. Await service is a reminder for the TCR list again.
Short date, lordship.
8/5. Item number 21.
May please, my lord. Section is 21B, but that is difference only for 8 gram, my lord, because police recovered the heroin only for 13 gram without container, my lord. And as per NDPS segmentation, small quantity is 5 gram to 250 gram. And 13 gram only for, my lord, the difference is 8 gram with container, my lord. And already he is arrested on 23, 2026, already 38 days he is behind the bar, my lord.
Only.
And he is innocent, my lord, falsely implicated in this.
FSL report, otherwise there are some.
Not only for 21.
Come up after a week.
Not, my lord, after, because only 38 days, or difference is not huge amount, my lord. Only for 13 gram is without that is the as per my lord forwarding report, that is clearly stated that without container is 13 gram, my lord.
So that is not an offense.
No, my lord, I am not involved in this case. I am falsely implicated in this case. He is
You are saying about 13 grams.
13 gram, my lord, recovered, and as per NDPS Act, my lord, a small quantity is 5 gram and maximum is 250.
Who has it been recovered from?
Recovered from not my position, my lord. That is the polythene is only one another friend, another car plater, my lord. He is dropped me in the road, and accordingly he stated me, you those some boy, and he flee away in the place of occurrence, my lord. I am falsely implicated in this case, my lord. He is not involved in, he is not do the offense, my lord. Working in the village area, my lord, not communication any bus and truck, bus and other small vehicle. Accordingly, I am working in the road. In the meantime, the vehicle driver was stated me. He dropped me. He helped me and dropped the bus stop, my lord. And I sitting his car, my lord. Thereafter, he stated me in place of occurrence. You go to the packet. Some beg, my lord.
He is from his body, my lord.
Not body,
And
my
he is
lord.
a peddler, my lord.
Not body, my
No,
lord.
I'm-
That is
I'm-
not implicated in
I am
this
submitting
FIR, my
on the
lord.
basis of, I am submitting on the basis of seizure, my lord.
Not it is given, my lord.
I can't even read your FIR.
FIR, my lord, page 9, my lord. Page 9, my translate copy is, my lord.
Have you submitted a typed copy?
Not given the type copy, my lord. FIR is there, I read this. Officer is a Soigram police station. Respected sir, I respectfully submit that on. Huh?
Page number 12.
Case number not F12. Case number 12, my lord. I respectfully submitted on 23/2026 at about 4:40 PM based on the reliable sources of the information. It was learned that one suspected person was loitering near the roadside on NS 17 at Bhatapara village.
This stage, on what basis do you say it was not recovered from you? You must have read the FIR.
Yes, I am reading, my lord. Accordingly, a general.
No, we have already read it. So on what basis do you say it was not recovered from you?
Not that is the stated the petitioner, my lord. He is the innocent. He is working in the road, and at the event, police recovered the plastic file containers, heroin, A1, 9 numbers of plastic container, and that is waiting. Total weight including file, my lord, 25 gram, and net weight and without 10 gram including in polythene, my lord. That is the recovered.
From you?
They inform about the process, seizure, and that is the statement, my lord, police, my lord. That is the police, some corroborated statement is
Who else
there.
will state?
Huh?
Who else will state?
My petition, my lord, I have statement in paragraph.
It was done in the presence of
Paragraph
witnesses.
2, my
Yes,
lord.
PP, statement of witnesses are there.
Witnesses are there.
Witness,
Recovered from him. So
That is also clearly says, my lord, it is recovered from his position.
but the difference is not so much, my lord, only for 8 gram difference, my lord. Not my lord pleader, that is your statement. No, I am not a pleader, my lord. That is the allegation, my lord.
learned counsel for the petitioner, learned additional PP decision application under so and so. As per the allegations discernible from the FIR. On the basis of prior information, the petitioner was found on 30/03.
1-3, my lord.
20/03.
Hmm.
26 near the roadside of NH 17 at Bhatapara village, and upon body search conducted on the petitioner in the presence of independent witnesses, a quantity of 13 grams net weight of suspected heroin was recovered from him, and accordingly he was arrested. Para learned counsel for the petitioner submits that the petitioner has been falsely implicated and he has already spent how many days?
38 days, my lord.
48 days behind bars. Para, on the other hand, learned additional PP submits that the CD, including the statements of the independent witnesses as well as the seizure list, clearly indicates that the recovery was directly made from the person of the petitioner. Para, having regard to the incriminating material available in the CD, despite the fact that the matter relates to intermediate quantity, and considering the larger social implications, the prayer for bail stands rejected at this stage.
Kindly, my lord, give me.
CD.
Give me, my lord, CD, update case diary, my lord, for some time, my lord.
Next item. Supplementary 45. May please, your lordship. Lordship 483 bail application lata.
my lord, Mr. Remote assist. This is routine month, I think.
Earlier occasion, lordship, the informant came on person, then the amicus was appointed. And case diary was read out, lordship, the allegation is that the complainant has reported his missing daughter, lordship. That is the allegation. The present petitioner is 19 years old and the missing daughter is 16 years.
Where's the affair?
Lordship, on page 12, lordship.
Yes, PP, what is the statement of the victim?
My lord, although my lord, she has stated that, my lord, he knew the accused person from last 1 month, my lord. But my lord, one day, my lord, she went to meet him, my lord. Then, my lord, it got late, so my lord, she is scared to come back to her house. Then, my lord, the accused person took him to Mandir, my lord. Then he promised her to marry. Thereafter, my lord, they have started, my lord, physical relation. And she stays there for 2 days, my lord, after the she returns. He stays there for 2 days, my lord, with the victim, my lord. Oh, sorry, with the accused, my lord.
Victim is 16 years.
From the heart, my lord, 183 statement, 15 years. Considering her age, my lord, although my lord, she has given consent, my lord, it cannot be, my lord, taken into consideration.
Petitioner is 19 years old.
Any age proof is there?
It is there, my lord. Her date of birth is 2010, my lord.
2010.
15/9/2010. Date of birth, my lord.
2002,
2010, my lord.
2010.
15/9/2010, my lord.
Not 16.
How many days in custody now?
Lordship, almost 70, lordship. Today it is 69, lordship. And as per my instruction, they were in love affairs, lordship. That is what has been told to me, lordship. And although the address in the forwarding record says Tinsukia, but he's been staying in Gauhati with his parents in a rented house. So he will appear for the trial when it is charge-sheeted. Considering his age, lordship. I only please that.
Yes, amicus.
Your Lordship, from her statement, it can be seen that she went there on the pretext that the boy promised that nothing would happen, Your Lordship, and which is why she went. Though she says that there's a love affair between the two, but Your Lordship, she was also 15 years, 4 months at the time of the incident. And she went only on the promise, on the belief that nothing would happen, Your Lordship. That is what is in her statement, Your Lordship.
That came from lordship that she did
Give
not.
us the statement, pass it over.
Statement.
Okay, we'll see. Campbell back.
46. Degree of life. The stringent condition may be imposed, Lordship. If you.
Wait, please, your lordship. Lordship, this is a regular bail application today 90 days, lordship. Initially, case was registered under 87 of the BNS, lordship. Subsequently, 6 of the POCSO is added, lordship. Forwarding report on page 18, lordship. So for forwarding report, lordship, since 6 of the POCSO is there, lordship, here 193 of the BNS, lordship, the statutory period for investigation has to be 60 days, lordship. Now 90 days in jail custody, lordship.
Section 6 is 60 days.
Yes, lordship, 193, kindly come to lordship, 193.
What is the
subclause two.
punishment?
Here, lordship,
20
specific.
years.
Even then, lordship, what is stated in this here, para 2, provision 2, lordship, the investigation in 193 subclause 2, lordship.
BNSS.
Yes, lordship.
Section 6 box.
Oh, section 6 box, that's specific.
$193.
Subclause 2, lordship.
PNSS.
Yes.
And the PNSS one. PNSS. It's right. Subclause, can you?
2. Take it, sir.
But for the purpose of default bail, wouldn't 187 be attracted?
Yes, but
It
here,
is
lordship, after
193
complete.
gives a direction to complete it within 2 months, all right. If it is not completed, it may have its
They have
own
to file.
consequences by way of departmental action or something. But when 187 specifically authorizes the magistrate
Yes, lordship.
to authorize detention up to 90 days.
Today
Yes,
is 90 days, lordship.
Yes.
Forwarding report on page 18, lordship.
Yes, to get your file, please.
এইটো 1/4 আহিছেতো মাৰ্চত ফাইল কৰিছে বেল এপ্লিকেশ্যনটো মাৰ্চত ফাইল হৈছে ডেফিনেটলি 1 এপ্ৰিলত আহিছে on the date of FIR হ'ব
So no, any instruction on charge sheet? No.
Till date. It was filed on 1/4/2026, Lordship,
What?
application.
No, it may have been filed, but 90 days will be over today.
Lordship, there is a note perhaps. Yes, Lordship. It has been filed, Lordship.
Filed.
Yes,
date
Lordship, date 31/2026.
31
31/2026.
A long back.
Within time.
31
That means within 60 days.
31 2020 within 16 days
That you asked to the court, I think that is not my concern.
but the lordship order lordship
So then let us have the scan copy then.
yes
It is stated that charge sheet has been submitted on 30.
Lordship, it was filed on 30/01/2026, filed search sheet number 10/2026.
Call for the scan copy of the TCR list again.
Lordship, we
date
have received the case, right? That may be sent back, Lordship.
Yes, there will also be required.
Then it may be.
Let it be here since they have filed a charge sheet right now. It is not necessary for them. Retain it. CD receipt be retained.
highly obliged
Right, CS number 10/2026. Dated 30/01/2026.
Your Lordship, may I pray it for it to be fixed on the 15th, Your Lordship?
All right.
15%. Your Lordship, I won't be available on the 14th, Your Lordship.
All right, give 15 then.
highly obliged
Number 47.
Your lordship is a regular bail application, your lordship. Under section 135 of the Custom Act, the maximum punishment is 7 years and the statutory period is 60 days. As on today, 58 days already under custody.
Lordship, we have filed our objection and also we have brought the CD, Lordship. Lordship, we would like to present the CD. Lordship, they have stated that there is no connection, but Your Lordship, the present petitioner was involved consciously, Lordship. It has been stated in our objection, if Your Lordship may allow me to read paragraph number 5 of our objection, Lordship.
It is apparent from the Panchanama that I am the driver of the vehicle, your lordship. Only because the owner who was supposed to send the documents through mobile phone, that was not in my position at the time of interception. That's why I am not on that, your
Stage
lordship.
of your investigation, you have not filed a charge sheet.
Yes.
Have you?
Action, Lordship, within the statutory period, the charge sheet will not be filed. That is the instruction I've received from the department, Lordship.
That is my case, your lordship. 58 days already, mandatory period 60 days.
And as to his involvement, he has voluntarily stated that
That will be-
he knew it, Lordship. Lordship, my humble prayer would be that if strict measures may be imposed so that he would be cooperating with the investigation, Lordship.
I am already behind bar.
Release all it or-
Submission. please.
Heard learned counsel for the petitioner and also heard learned counsel representing
Department.
Customs Department. This is an application so and so. As per the allegations on 02/03/26. A truck bearing registration number AS 11FC 7733 was intercepted at Sonapur toll gate, Kamrup Metro, and suspected Ereka nuts of foreign origin was recovered therefrom, and accordingly the present case was registered and
Customs
The-
seizure case.
petitioner was taken into custody. Where in the meantime, investigation has progressed, but till date, charge sheet has not been submitted. And the petitioner has been behind bars for 58 days.
58.
Learned counsel for the customs, upon instructions received, has submitted that the investigating agency would not be in a position to submit the charge sheet within the statutory period. So however, it is submitted that strict conditions may be imposed in the event of the petitioner being granted bail. Para having regard to the aforesaid submissions, it is provided that the petitioner so and so shall be released on bail of rupees 1 lakh with 2 sureties of like amount, one of whom would be a government servant. To the satisfaction of the IO. And it is further provided that the petitioner shall cooperate with the investigation and shall not try to influence or intimidate the witnesses or hamper the investigation in any manner. With the aforesaid directions, the instant bail petition stands disposed of.
Much obliged.
Hearing 22. Thank you.
Your Lordship, in this matter, CD is not available. CD may be called for.
Not available.
He did not receive my lord today.
They did not receive list again on so and so interim order. was available.
11/5, my lord.
23.
Much obliged.
May I please, your lordship? This case, my lord, we have received the case diary, my lord, and accused person is on interim, my lord.
Yes,
But
Lordship.
CD is not up to date, my lord. Whether they have appeared before the IO or not, my lord, it is not clear, my lord.
Lordship,
So may I pray that, my lord, up to date case diary may be called for.
Lordship, after getting the interim Lordship, we appeared before the concerned IO Lordship. And Lordship, in a case of 2024 Lordship, the 2025 Lordship, incident took place Lordship 24 Lordship. Yeah, Lordship. And Lordship, it's a completely civil nature Lordship. Yes, Lordship. Here Lordship, the informant sold her auto vehicle Lordship. In 1980. Yes, Lordship.
You are on interim anyway.
Yes, Lordship.
But learned additional PP submits that updated CD may be called for. Hence list the matter again on so and so interim order passed earlier to continue. Next date of listing.
24.
Mass oblige.
Not received today.
Not received.
I'm on interim, my lord.
Same order, interim control.
Oh, let's. 12/5, my lord. 12/5.
27.
Made with the lordship.
Yes.
Then kindly find the FIR at page number 11. This FIR is, with due respect and humble submission, I wish to state that on 2/2/2026, information was received from a reliable source that several under trial prisoners and convicted prisoners were conspiring to escape from jail custody by using communication devices inside the campus of district jail. Accordingly, GD entry was made. Following instructions from superior officer to anchor the matter, I so and so, along with other staff, left the PS by GD number so and so. We arrived at the Sribhumi district jail campus to conduct surprise search. After completing all necessary formalities, a thorough search of the jail cells and inmates was conducted. During the search, the following prohibited items were found: some mobile phones and some cigarettes, lighters. All these things were found. Further, as per Assam Prisoners Act, a prisoner is strictly prohibited from using communication devices or possessing unauthorized items. The recovery of these items, especially the communication devices and sub payments, strongly suggests a conspiracy for a potential jailbreak. It is also suspected that
Who are you?
No, Lordship, these petitioners at that time, for a particular period of time, they are serving as assistant jailer. Now, they were working under the district jail authority, district jailer, Your Lordship. Now, at the relevant point of time, they were not present. After the search, they were called, they were made Caesar witnesses, and their statements were also recorded, Your Lordship. Subsequently, Your Lordship, by way of a transfer order at page number 15, immediately after the incident on 16/2/2026, they have been transferred. And now petitioner number 1 is at Hamren and petitioner number 2 is serving at Nagaon, Your Lordship. Your Lordship, they were basically assigned the duties of official work while the main district jail warden, he used to supervise all the things, Your Lordship. In the meantime, the IO has made an application at page 13 that section 7 of the PC Act is required to be added. And on the basis of that, Your Lordship, the Honorable Court below by order at page number 14 has added section 7 of the PC Act, and therefore the petitioners apprehend that they may be called. Already they appeared earlier, their statements have been recorded, they have already been transferred from their, Your Lordship. And as such, there's no allegation against them.
Yes, PP.
I just place the case diary, my lord. There is a note of the investigating officer, my lord. So, may peruse the second page of the, my lord, case diary, my lord. Sorry, my lord, the note of the investigating officer, my lord. That is in a nutshell, my lord, what they have found during investigation. Second page, my lord. Yes, that paragraph. The allegations are very serious, my lord, because the petitioner number 1, my lord, he was the assistant jailer at that point of time. And petitioner number 2, my lord, he was the jailer, my lord.
No, he was
By taking, my lord,
he was
taking
of
money,
assistant jailer.
by taking money, my lord, every month, my lord, they used to provide mobile phone, my lord. To the, my lord, under 12 prisoners, my lord.
Both of them were assistant jailers, Your Lordship.
So the allegations are very serious, my lord, so their, my lord, custodial interrogation is very much necessary, my lord. At this stage, my lord, I am opposing this, their bail claim. And there are also statement of the, my lord, accused person, my lord. My lord, they used to provide mobile phone, my lord, by taking money, my lord. Statement, my lord, those statements.
Counsel for the petitioner and additional PP, this is an application under so and so.
I'd
The-
like to refer to page 13, your lordship only. Page 15 is the transfer order, your lordship.
What does the relevance does it have?
No, lordship will kindly see page 13 for a moment, then lordship will say. Page 13. Whether they are at all, they are young recruits, your lordship, they are working under the jail, both of them are assistant jail warden, your lordship. Page 13, lordship has got it. Second paragraph, I read, during investigation, the PO was visited, drew a rough sketch map of the PO, available witnesses were examined, shown, arrested 23 number of accused named so and so, so and so, and so, after taking proper permission from the honorable court. Now, during the interrogation of the shown arrested accused persons, also stated that they got mobile phones through jail warden Subhashish Ghosh. I am not Subhashish Ghosh. And they used to bribe assistant jailer Rudra Deori, the petitioner herein, assistant jailer Vishwajit Barua, the petitioner herein, warden Subhashish Ghosh and jail Jamadar so and so on per month basis and one time for using mobile phone inside the jail. And lordship will kindly see the last line. And they used to make the monthly payments to the jail warden Subhashish Ghosh, your lordship. He was the warden, your lordship. He used to collect money on their names, your lordship. They are totally new recruits, your lordship. They were working under this jail warden, your lordship. And immediately after the incident, your lordship, they have been made seizure witnesses. They appeared and their statements are also recorded. And they have also been transferred, your lordship, immediately after the incident. Lordship, these are all allegations, your lordship. They will appear before the IO as and when recorded, and they are government officials. There is no chance that they will fled away or there is any chance of hampering or tampering with the witnesses, your lordship. The allegation is that the jail warden used to collect the money, your lordship, on their name, saying that you have to pay, give money on the name of assistant jail warden also. That is what they said in the petition. On the basis of that petition, your lordship, at page 14, the honorable court has added section 7 of the Prevention of Corruption Act.
Then my lordship may kindly peruse the my lord case diary, my lord, where is my lord, the accused person, the other accused person, my lord, their statement also recorded, my lord, what they have said, my lord.
What are the names of the present petitioners?
Rudra Deori
Vishwajit Barua.
and Vishwajit Barua. They were, both of them were assistant jailer at that time, your lordship. They are new recruits, your lordship. One is recruited in 2018, one is 2023, your lordship. They used to work directly under the supervision of the jail warden, your lordship. And the correction was made by the jail warden, your lordship. All the arrested accused persons are arrested, your lordship.
All that is negated by the CD. You were directly hand in glove. You used to receive yourself.
No, that is not there in the page.
Of course, it will not be there, but it is there in the CD.
These are all, and they have already been transferred. There is also no chance that they will hamper or tamper, your lordship.
Counsel for the petitioner, not an additional PP decision application, so and so. The principal allegation as reflected in the FIR was that on the basis of information received, a search operation was conducted in Srifumi jail and a large number of mobile phones were recovered from the inmates of the jail. And upon further investigation, it was revealed that the said mobile phones were obtained from jail warden Subhashish Ghosh and the present petitioners along with other jail staff used to receive bribes from the inmates in order to enable them to operate the mobile phones. Full stop. Learned counsel for the petitioner submits that even as per the FIR, it was the jail warden who had received the bribe money by taking the name of the present petitioners, and there is no involvement on their part. Full stop. However, a perusal of the case diary belies such contention and reveals sufficient incriminating materials against the present petitioners. Having regard to the above as well as to the seriousness of the allegations, this is not a fit case for grant of pre-arrest bail. Accordingly, the prayer for pre-arrest bail stands rejected. Send back the CD.
28. Oblige, lordship.
May I please ask? But I am in time, I appeared before the IO also, madam.
No, FIR is at page 11, madam. Yes, sir. CD received. Any involvement of the petitioner is revealed?
Some unauthorized education, religious education institution was running by the petitioner along with his associate in order to confine some minor children, Lordship. From 15 to 25 numbers of children were confined in a place whereby, Lordship, it was revealed that some pornographic contents were found to be stored in the mobile phones of the associates, accused persons, along as well as in the mobile phones of the children, Lordship. This raises threats and suspicion of children exploitation as well as abuse of the children, Lordship. So this is a serious nature allegation.
Now, can you see page 11, ma'am? What is the actual allegation, madam? Madam, on my appearance, man, my mobile phone has never been seized, my lord. Whether any material is there in the mobile phones, my lord, they ought to have seized my mobile, my lord. Whatever material has been found from the
No,
mobile.
owner of the land is admitted. I am asking
Yes,
about the specific role.
Yes, madam. Now, madam, page 11 is the FIR, madam. My role is that, my lord,
My Lordship.
madam, I am the owner of the land, my lord, where the
conduct
madrasa is going on, my lord.
Because he knows everything, Lordship. Some illicit things are going on. And they have used a minor voice, Lordship.
Madam, whatever is done by the accused number 1, my lord. I am just providing the land, my lord.
It is also known to him very well that something is. Lordship.
What is the specific implication of the petitioner there?
Page 11 only, my lord.
No, in the CD.
I have gone through the statement of the victim, Lordship. They have stated that they asked this petitioner along with the other associates asked to sleep the minor boys on floor, and thereby they used to see the pornographic contents in the mobile phones, Lordship.
We have marked the things. We'll take it up after lunch.
Then on my opinion, they ought to have seized my mobile phone, my lord. Whether this kind of materials are available in my mobile phones or not, my lord. They have seized my mobile phone on my appearance also, my lord. Otherwise, when the mobile phone of the first.
Okay, we'll continue after lunch.
But
In this case, the informant is an outsider.
yes, madam, it's a local.
But there are victims. What
The
about
victim statements are there, Lordship.
what about their representation?
Statements are there, Lordship.
Yes. Should they not be represented by an amicus or somebody?
Victims are minor, Lordship.
Allegation is about December 2025, madam. Already 5 months has been gone by, madam. Allegation is of 2025, madam. December 2025, madam.
FI is about 18 to 25 minutes. My custodial interrogation is required or not, madam. That is the crux of the matter, madam. Since I am appearing before the investigating officer, madam, and I am cooperating with the investigation, madam. One second.
81.
What is the name of the main accused?
Soiful Islam. Soiful Islam. madam. I have annexed the forwarding report also on the Soiful Islam page 22, madam. Soiful Islam has run the institution, madam, the madrasa. Soiful Islam madam, used to run the madrasa, madam.
And present petitioner is the owner of the premises structure. Children were wrongfully confined, minor boys.
There is an observation in the last order that notice to informant stroke appointment of amicus should be considered after receipt of case diary. Notice may not be because informant
Yes,
is
sir. He's a local person.
somebody else. At least we should appoint an amicus.
P. Parasa.
Anybody is available here?
কপিটা দিয়ে দিও।
He is available.
You are?
খন্দকারে
K.M. Hassan. I had learned counsel.
I am providing the copy also, madam.
and learned additional PP. CD has been received. Mr. K. Hassan is appointed as amicus. Huh? Hassan. K. M. Hassan is appointed, as learned counsel is appointed as amicus curiae to represent the informant stroke victims. A copy of the petition has been handed over to the newly appointed amicus curiae. Lays the matter again on so and so, showing the name of learned amicus curiae. CDB retained.
But the intent may be convenient.
Hmm?
The intent may be convenient.
Yes, interim order passed earlier to continue.
At this point, doing this.
Yes.
CDB retained, Lordship.
No, CD retained.
Obliged.
29. 29 মানে charge sheet submitted.
The interim portion may be given, Lordship. I will be aware with code below. Interim may be production.
You will appear.
No, no, I will appear.
Interim not given earlier.
I will not.
He'll appear, huh?
What is the offense?
POCSO 10.
POCSO. 10 of POCSO, that means it is bailable by magistrate also. 3 years, is it not? 5 years.
5 years maybe. 5 years maybe. Expect
Up to 7, I think.
below 7.
A magistrate can grant.
Expect will come.
Anyway, this will be before special judge, I think. No.
Well,
Hard learned counsel for the petitioner. Learned additional PP has submitted, the charge sheet has been submitted in the case by CS number
103/2026 dated 25/4/26.
It is submitted on behalf of the petitioner that the petitioner shall appear before the learned special judge POCSO Bilasipara. Is it Bilasipara?
Yes, Lordship.
And apply for regular bail. Accordingly, this petition is disposed of with a direction that the petitioner shall appear before the learned special judge POCSO Bilasipara within a period of 10 days from today. And in the event of any bail application being filed, the same shall be considered as per law. Petition stands closed accordingly. None appears for the petitioner list again on so and so.
It is available. Next week.
CDB retained till the next date.
32.
May please, Your Lordship. Anticipated bail application, Lordship. Offense, Lordship, under section 21B, 27A, 29 of the NDPS Act, Lordship. The allegation is that, Lordship, but during Naka checking, one e-rickshaw was intercepted, and from the e-rickshaw, 2 persons were apprehended. And Lordship, from the backside of the e-rickshaw, Lordship, total Lordships 72 grams. 72 grams of suspected to be heroin was recovered, along with soap cases, Lordship. And Lordship, allegation against me is that I obstructed the Lordship police personnel from discharging their duty, and Lordship trying to Lordship save those accused persons, Lordship. Lordship may kindly see page 15 for a moment. I am a Lordship Gau Pradhan, Lordship. Page 15. Allegation against me, Lordship may kindly see in the middle portion furthermore. It starts with furthermore. As the police party prepared to depart from the PO, one Julhasuddin Namer, that is the present petitioner, Lordship, resident of number 2 Islampur, PSL, who identified himself as the Gao Pradhan of the number 2 Islampur locality, positioned himself in front of the police vehicle. He obstructed the public servants in the discharge of their official duties and instigated the local mob to block the road, claiming the accused were innocent despite them being caught red-handed with NDPS consignment. Subsequent inquiries revealed that Julhasuddin habitually harbors NDPS-related accused persons for financial gain, thereby grossly misusing his official position as Gao Pradhan, Lordship. This is the election. What happened is that I, being the Gao Pradhan, went to the Lordship PO to take stock of the situation, Lordship. But this allegation is not, Lordship, at all, Lordship, true, Lordship. I being the Lordship Gao Pradhan went there to take a look at the situation, Lordship. And Lordship, I am a government Gao Pradhan, Lordship. You can see page number 18. This is the I-card, Lordship, booth level officer, Lordship, issued by the ECI. Then page 9, Lordship, designation Gao Pradhan, Lordship.
That is there, Malad, but yes, on that day, Malad, when police tried to bring those persons, seize the drugs and tried to take back to police station, Malad. He being the Gauparan, he obstructed the police party, Malad. That is, and 3 independent witness of the village, Malad, they have stated that Malad, no physical, this is not there, but Malad, abused language has been used, Malad, and gali galas kore this. This is the Malad. By that 3 numbers of witness.
Lordship, 21B will not come, Lordship. Obstructing the police personnel, Lordship, that Lordship, I will cooperate with the investigation, Lordship. I being the Gao Pradhan, Lordship.
No physical, that is not there, Malad.
And those 2 persons are already apprehended, along with the suspected to be, Lordship, heroin, Lordship. So NDPS, Lordship, offenses sections may not be applicable in my case, Lordship.
Any connection with these 2 persons whom he tried to save?
It's witness not said like that, Malad. আরক্ষী দল তো কাম কাজ করার অসুবিধার সৃষ্টি করে বাধা দিয়ে ঘটনা তো দেখিছো রিগার্ডিং দ্যাট অনলি মানে
I'll cooperate. I am a local person, Lordship.
Hard limit counsel for the petitioner. Additional PP. This is an application under so and so. It appears from the FIR that 2 other accused persons as named therein were apprehended while they were traveling on an e-rickshaw, and an intermediate quantity of suspected heroin was recovered from the backside of the said e-rickshaw. And when the police apprehended the said accused persons and were in the process of taking him away to the police station, the present petitioner, who was the Gao Pradhan, obstructed the police officers. Full stop. It appears from the CD that no physical act of obstruction has been attributed to the petitioner, and only use of the slang language has been mentioned. So, having regard to the above, it appears that the provisions of the NDPS Act are not affected in the present case, as far as the present petitioner is concerned. Accordingly, the prayer for pre-arrest bail is allowed. Petitioner so and so in the event of his arrest shall be released on bail of rupees 50,000 with 2 sureties of liability to the satisfaction of the arresting authority in connection with the aforesaid case. It is further provided that the petitioner shall cooperate with the investigation as and when called for and shall not try to influence the witnesses of the case. Petition stands allowed accordingly. Send back the CD.
Keep your presence.
My lord, TCR has not been received.
Yes, my lord. But the official dated, it has not been received, my lord, 24/4/2026, my lord. My lord, petitioner behind the bars, my lord, 249 days, my lord, a short date be given, my lord.
Scan copy of TCR not yet received issue reminder list again on.
Acknowledgement.
May I please, the lordship?
Yes.
Here in this case, lordship, here in this case, lordship, this petitioner is a tax collector, lordship. Now, what has happened, he has collected the tax, and this allegation is that some excess amount has been collected.
What tax?
Lordship, this municipal tax, and accordingly, as a chart is given in the FI, I'm just referring to the concerned FI, lordship. It is at page number 14. Page number 14. Now, in this particular FIR, a column is there illustrating the example of fraud. Now it is there in page number 16. Lordship, kindly peruse the name of certain persons. And here it is mentioned that a amount paid, fake, duplicate record, and amount deposited, genuine receipt. So the authorities, the municipal authorities, they have received the amount that is there in actual terms, lordship. And there is no this section by which the case has been registered, the breach of trust. It is not there on the part of the, so far as the authorities are concerned, lordship. And here in this case, the concerned persons who have paid those amounts, they are not making any allegation against the petitioner. Only thing is that the authorities are saying that certain excess amount has been collected, but it is not a case of misappropriation, lordship, because it is there. If you, lordship, kindly peruse the amount deposited, the genuine receipt, all these amounts are there. It's a mere, lordship, this tax collector, and he will cooperate with the investigation, lordship. And just praying for some protection at this stage, lordship, since the CD is there. And lordship, this FIR is of November 2025, probably some investigation has taken place. And only with regard to collection of some excess amount, that is the main allegation. And the government exchequer, there is nothing like misappropriation in the government exchequer, because the amount which is there, yes, it is mentioned in page number, paragraph, this page number 16. He has deposited that amount, lordship. And the persons who had paid those amounts, they are not making any allegation against the petitioner, lordship.
Who has not made allegation?
These persons, lordship, this Abhinoy Nath, Jayanto Roy, Ujjwal Kanti De, these are the pairs, lordship. They have made the payment with regard to so far as the allegation of excess amount is there. But in the said column, it has been mentioned the amount deposited, genuine receipt. The authorities have received the genuine amount. So if that be so, lordship, there is nothing like.
Where is shown authorities have received?
Yes, page number 16, lordship, kindly see the column. First, second, third, fourth, and fifth. Fifth column, page number 16. The illustration or illustrative example of fraud. The name of the parties are there, Abhinoy Nath, Jayanto Roy, and Ujjwal Kanti De. Now the financial year is there, the amount paid, and the amount deposited, genuine receipt. So as per the genuine receipt, lordship, the amount which is there, as far as the tax is concerned, that amount was deposited, lordship. And if the excess amount, if I've collected something from them, they are supposed to make the allegation that a certain excess amount has been collected, because they are saying the allegation is with regard to misappropriation of government fund. There is nothing like misappropriation of government fund is their lordship, so far as the allegation is concerned. Because whatever the amount with regard to this genuine receipt, the petitioner has deposited that amount. I'm ready to cooperate with the investigation, lordship, in all possible ways, lordship.
Who is that joining? Kun join good. To kun join good is it direct online?
It's a different matter.
Yes, any.
As per the case study is concerned, so petitioner is a public servant who is entrusted with the job of to collecting taxes from domestic households and accordingly to pay the same to the municipal authority, but they have demanded excess money by procuring false document receipt, and thereby they have siphoned the public money also.
What is the material with regard to that they have collected excess money? Any complaint from the persons who have paid?
Lordship, kindly go through the case theory, Lordship, as per Caesar list, Lordship, property receipt assessment has been, tax paying receipt has been seized. Whereby it is shown that they have collected much more amount than the required amount. Lordship.
No,
Sufficient
receipt
details-
says which amount? The amount in column 5.
Lordship,
Yes. Column 5.
Lordship, I'm reading the statement of the taxpayers' statement, Lordship, what they have stated, Lordship. Lordship, the statement of one witness, Lordship. My name and address is mentioned above. I paid my house property tax at Sribhumi municipality of rupees 6,678. And accordingly, they gave me the receipt with seal from tax collector branch of Sribhumi municipality office. When I got the news about municipality chaos, then on so and so date, again visited municipality board to recheck my payment. My first receipt payment was 6,678, but when I checked, it shows rupees 2,200 in the website. Then I came to know that the first junior assistant, namely Rahul Chakraborty, the present petitioner, and Arvind Das, his associates assigned to tax collection branch, gave me a fake receipt, and they have collected rupees 6,678 from me and only deposited rupees 2,200 in the government fund. That's all I have to say. Same sort of statements has been given by the lordship's victims. And the FIR was lodged by the chairman of the municipality of Sribhumi, Lordship.
FIR can be lodged by anybody.
But they siphoned a public fund, Lordship.
Government money. It's not a government.
No, even if it is not public fund, they have cheated the private persons.
Money has been siphoned. They have
No, what is the amount due?
2,200,
No,
3,200.
What was deposited with the municipality that?
100 deposited, but they have asked for much more than this.
Yes, but what was the actual rate?
4,000.
6,678 has been asked for, but they have deposited 2,200.
No, what was the amount due actually?
2,200. That is what I'm saying.
That is the due amount.
Exactly, lordship.
So instead of the due amount, they collected in excess.
Excellent.
Giving a fake receipt.
Fake receipt.
Lordship, I'm ready to cooperate with the investigation, Lordship.
Their governments are
I'm ready to cooperate with the investigation in all possible way, Lordship.
blunder on their side, Lordship.
Blunder is there, Lordship, but there is no purpose, justified reason for
That
the
is justified, Lordship.
custodial
They have
interrogation,
collected
Lordship.
illegally excess amount.
I am ready to cooperate. I am ready to explain each and every aspect of the matter, Lordship.
Highly required because it is
I
still
am-
there to, it is necessary to
I am a
ascertain
government
the
servant. I'm staying in that particular area.
It's appropriate and identify the other possible associates, Lordship.
If I cooperate with the investigation, Lordship, because there is
Documents and to honor the modus operandi.
so
prior
FIR of
game,
2025, Lordship. Now it is 2026. For last 6
objecting at
months,
this
nothing has
Sufficient
happened, and they have-
materials, Lordship may go
They
through
have
the.
collected
case
all
study.
the materials, Lordship.
Madam,
Since they have collected all the materials, there is no further requirement of the custodial interrogation, Lordship. I am praying for,
so how much they have misappropriated, that has to be yet to be
it's a matter
ascertained.
of trial, Lordship. Because I will cooperate with the investigation in all possible ways, Lordship.
Time required, Lordship.
What is the, it was earlier rejected.
Yes.
What is the new ground now?
The new ground, Lordship, the person is suffering from various ailments. I have annexed certain medical documents, and at present, Lordship, he is required to be admitted in the hospital. But because of this pending case, he is not in a position to do that, Lordship. And for last 4, 5, 6 months already elapsed from the filing of this registration of this FIR, Lordship.
Earlier rejected.
They have
case,
collected all the necessary information, Lordship, by that period of time. Because these are all documentary evidence, nothing like that I have to specify certain thing or I have to give certain statement with regard to the offenses alleged by the informant, Lordship. I will cooperate, Lordship, in all possible ways. I will place whatever information I am having. Lordship may give some sort of strict condition. I will comply with all these conditions and I will appear before the IO in all.
No, we have rejected your bail earlier.
Yes, Lordship.
Unless there are some strong and new grounds, then we are not inclined.
Medically unfit, Lordship, he is required to go outside because of this pending case, Lordship. He is not in a position to
Who
take
is
care of
stopping
his
you?
health, Lordship.
When
Kindly
was it
consider-
last rejected? 22/1/26.
Yes.
3 months have gone by. What happened to your medical condition?
Lordship, because of this pending case,
Your
Lordship, I am
medicals
not in a
look,
position.
this is of 2024.
Yes.
Your certificates are of 2024.
No, that is what I'm submitting, Lordships 24 because of this pending litigation, Lordship. I'm
Your
not in a
submission
position to
doesn't
go to
make any
doctor, go
sense.
to other place, Lordship. And prima facie, Lordship, the allegation that has been made by the concerned person, the informant, there is nothing like misappropriation of government farm, Lordship. If I have done something, it is to be alleged by the concerned person from whom I have collected.
I'd learned counsel for the petitioner and learned additional PP. This is an application under so and so. Page 24. CDS call for has been received. A previous bail application being AB 41 of 2026 was rejected by this court by order 22/01/26. Para the only new ground sought to be projected in the present application is that the petitioner is suffering from heart ailments for which he is required to go outside the state for medical treatment. Full stop. I have perused the annexures.
Page 21/20, Lordship.
Related to the medical condition of the petitioner, which are from the year 2024. And therefore, they are no longer relevant for the present time. And it is, nothing is mentioned as to what treatment the petitioner has undergone in the period of more than 1.5 years that have elapsed since then. Having regard to the above, I do not find any merit in the present application and accordingly it stands dismissed. Send back the CD.
49.
May I please, your lordship, but in this case, on the last day, diary was called for, my lord. My lord,
CD not received.
CP
lordship.
submitting, my lord, diary is not before your lordship, my lord. I only pray that can it be protected for the limited duration. my lord. What happened in this case, my lord, GST authority made a raid in my farm. So, I am a CA, my lord, by profession, my lord. Then certain articles were recovered like seals and all.
Like?
Seal. Government seals, my lord. But the search itself is shrouded with mystery, my lord, because of the fact, my lord, that while conducting the search, my lord, the CCTV of my thing was switched off for 3 hours. 3 hours, my lord. And in the meantime, in the main case, I have already been granted bail, my lord.
Main case means?
The GST case for which the raid was conducted. While conducting the raid, they found certain things, my lord. According to us, it is a plan.
Second case is there.
Yes, ma'am. And the first case, we were granted bail, my lord, within a short period of 4 days. Then the GST authority went to the PS and gave the information, ma'am. We have made all the mentions, method in our petitions by incorporating all these statements of facts, my lord. And nowadays, my lord, page 8, my lord. Para 12, my lord. Actually, nowadays, my lord, while making any seizure under the Nyaya Shaksha Evidence Act, my lord, these should be all photographed and kept it in the thing, my lord, cloud, so that anybody can see and assess it, my lord. I have stated in para 11. And I have also annexed the rules, my lord, framed by the government, my lord, Annexure 4. Applicant begs to stay and submit a section 185 of BNS mandates that whenever a search is to be made, the entire search operation shall, the police officer or other officer conductor shall be recorded through audio, video, electronic means, preferably by mobile phone. The said provision read with the rules framed thereafter imposes an obligation of procedural regularity upon the officials executing the search so as to ensure transparency and accountability of the search proceeding. But in the present case, the opposite party authority has failed to follow the said procedure. And I have annexed the rules framed by the government, my lord, that Annexure 4, my lord. It is starting from page 40, my lord. And it is further fortified by Annexure 5. The GST authority has issued a SOP, my lord, as to when its inspection of search and seizures were made. But this thing were totally violated, not complied with, my lord, which are mandatory in nature. Complete absence of video recording combined with the CCTV blackout for 3 hours means that there were no independent and verifiable record, my lord, of what transpired during the search.
Please, I am praying for calling. for the case
Let
study.
the diary be called for. In the meantime, I may be protected, my lord. That's my.
Lordship, I'm objecting.
Diary will speak everything. Let it
Because
come, my lord. No problem for that.
From
Let them
government-
take a comfortable date, my lord.
Government
But in the
documents and
meantime-
government steps has been recovered from the premises of the petitioner lordship, whether there has been. there have
The
been-
main offense here has already been granted
Granted.
bail, and again on procedural grounds.
It is a matter of trial lordship.
I think in there also, this search and seizure operation was
Not followed. No.
halted by
Yes.
the.
Short date may be given lordship. Anybody.
How
They
short?
were given short date only, but in.
How short?
Lordship,
No
I
more
ask you
short.
what is the convenience of the court.
Let them in the other hand take a comfortable date, my lord, and in the meantime, my lord. I'll abide by, I'll appear before the authority, my lord.
So the otherwise allegation is regarding finding of those.
Oh, yes, my lord, seal, my lord.
That is only the-
Using is not there. Nothing has come that I have
Government-
used those seal.
Government-
Now, whether it was a planted one or somebody brought in, not used.
The
So
CD
actually,
will
the
written
law
everything,
says that it should be
You
used.
simply say, CD not received. I was directed to produce the CD on the next day fixed. Place the matter again on so and so. Till then, no coercive action shall be taken against the petitioner.
That will do.
My objection may be recorded also.
Hmm?
Recorded.
We haven't been heard you.
Much of it, my lord.
Order item 34.
May I please your lordship? During pendency of the criminal revision petition, I
Lordship, Mr. Exhibitions is appearing on behalf of the petitioner. I'm paying for time to file objection against the substitution application, Lordship.
my lord, on each and every date from the last 3 days, my lord, after receiving the LCR, they are placed defined grounds. They could
Lordship, kindly fix the short date, Lordship.
on defined days they took time regarding this. I have submit one citations also. If your lordship may go to para 15, that substitution of legal here may be allowed in this regard. And the FIR lodged in the year 2011. Thereafter, from the charge sheet, their name was investigating officer based on the one report of the civil hospital that the petitioner was not present on the spot, and based on that report, his name was discharged from the charge sheet. Thereafter, the honorable additional session judge took cognizance, took summons against him on 18/12/2018 to appear before the trial court. Immediately, without appearing before the trial court, they approached before this honorable court, and by misleading this honorable court, they took a stay in this matter. And this honorable court, by the order dated 12/23/2019, stayed the petition. And immediately after 1 month, I have filed one substitution petition. And in this citation, it is clear. And your lordship directed me to submit, provide the citation to them. Accordingly, I have provided on 27/2/2026 to go through the citation. Thereafter, on 25/3/26 and 1/4/2026, they took time to defend plea. There is great suspicious, my lord, and there is a prima facie. And on the spot, the victim was died, my lord. This is under section 302 and allegation under section 302, 307, 147, 149, and 457, my lord. So further time may not be granted, and this petition I at least may be disposed of today, my lord.
Lordship, kindly fix that on day after tomorrow, Lordship.
No, my lord. Defined is defined plea only to delay the matter, and since a long pending matter, my lord. 2011 FIR was lost. And in the trial court case is fixed for argument from 18/7/2025 evidence was closed. And on 13th occasion case was fixed for argument, my lord. Is Chand Devi Daga, para 15. 14 is important. I have another judgment also, Jimmy Jahangir Madan. In this judgment, the Supreme Court also allowed the legal hearing if the complainant was expired during pendency of the case. In case there is no case, my lord. My humble prayer that today the IM may be disposed of and a short date may be given for criminal revision petition hearing. As in the lower court, matter was fixed for argument for a long period of time, my lord. And in the impugn order, the Honorable Additional Session just clearly stated regarding 319 issuing of summon, my lord, page number 34 in the main criminal revision petition.
You are the original informant.
Yes, I am the informant. This is a heinous crime, my lord. On the spot, the penis of the victim was cut, and on the spot he was died, my lord. And by profession, in the petitioner by profession is a police officer, my lord, and he can mislead anyone. By influencing the other police officer, he from the charge sheet his name was deleted.
So at the time of referring the revision, informant was already dead.
No, my lord. First day they took stay. Well, I was not appeared. Yes, order dated 23/2024. Then the notice was issued. And LCL also, TCR also received, my lord, in the deposition of the chief of the PWs, they have clearly stated that the accused person thereafter visited the house of the victim and threatened him to sign one blank paper. If they did not, then he will kill them also. PW2, Abdul Sahib so and so, several other person had come to my residence at night and had taken my signature and that of my mother, Nupurjan Bibi, my grandmother so and so, on blank paper and had threatened us to killing if we did not put our signature on the same. He is a police officer by occupation, my lord, and he so today the IL may be disposed of, my lord. I for substitution of legal heirs if the informant was died. And para 14 in that judgment, it is very clear. And I have another judgment also, 2004 12 SSC 509. In this judgment also, the Supreme Court clearly held that if the complainant was expired during pendency of the case, then legal heir may be substitute. Well, the additional session judge issued summon under section 319 to appear before the trial court. He directly approached before this honorable court, and by misleading, state the proceeding. And since then, this matter was pending, my lord. Other time may not be given, as the evidence already been closed. Today, at least, my lord, I may be disposed of, as your lordship aware that on the last 3 occasions, they took time on different ground, only to delay the matter. Thereafter, a short bit may be fixed and the criminal revision petition may be heard. In the evidence part, my lord, PW 1, 2, 3, they have managed everyone, including PP also, my lord.
All right, we'll allow this now, but we'll leave the question open in case of hearing of the main petition. If this question is raised, we'll reconsider it.
Please together, I may be disposed of.
Third learned counsel for the petitioner and learned counsel for the respondent. This is IA. Okay. IA 1050. This is an application seeking substitution of the respondent number 2 stroke informant in view of his death by his legal heirs. That is, who is the legal heir? Haris Ahmed.
No, my lord.
Zubeda.
Yeah, Jubeda. Jubeda was expired.
Huh?
Jubeda was expired. Legal heir of Jubeda.
Who is legal heir of Zubeda?
Riyazuddin, page number 4 in the IA. Brother of the victim and son of the Jubeda.
The following legal heir, okay, paragraph 4. They are having regard to the decision of the Honorable Apex Court in Chand Devi Daga and others versus Manju A. Umatani and others. 2018 1 SCC 71. Prayer for substitution is allowed. The name of the newly substituted respondent be inserted in the cause title as respondent number 2. Three. As respondent number 3, necessary application for amendment be filed accordingly. Most of in the main appeal, I stands disposed of accordingly. The connect in the main appeal, which is 2 appeals are two revisions are there. What one? 88.
88 of 19.
Yes, that you right. Third learned counsel for the parties. In view of order passed in IA criminal 1050 of 2019. Comma. So and so has been implemented, substituted as respondent number 3 in place of deceased respondent number 2. However, the question of maintainability of the criminal revision petition upon the expiry of the original informant is kept open.
And this matter may be taken up in the month of June, my lord,
Leaves
third week.
the matter after necessary corrections. In on is give a date.
10 June.
Hello. Date
Wait, Lordship.
10. Hearing day na? Hello, please.
Supplementary item number 50.
May it please your lordships. And this application is for extension of the period for appearance, my lord. Lordship has passed an order that is page 8, my lord. In this case, lordship allowed the applicant to appear before the IO within a period of 14 days, but after obtaining the certified copy, my lord, 14 days has already been elapsed because during this time it was holiday, my lord. So he won't be able to appear. my lord. So I may be allowed to.
Counsel for the petitioner and learned additional PP. This IA has been preferred seeking extension of time to appear before the IO
Was it try, no?
No, but it-
in connection with so and so case, the case number, okay, para 2.
AB 719/2026.
Lagans PS case number 12 of 2026. Corresponding to ZR case number 41 of 2026. This court by order dated 08/04/2026 at in AB 719 of 26 had granted a time of 14 days to the petitioner to appear before the IO. But due to the time taken in obtaining the certified copy of the order, the said 14 days has elapsed and therefore the petitioner seeks extension of time. The prayer is allowed further accordingly. Further 14 days time from today is granted, during which the petitioner shall appear before the IO. The IA stands disposed of accordingly. This order shall form part of the order dated 8/4/2026 in AB 719 of 2026.
My lord, list this matter after 14 days.
No, that isn't it.
Disposed of.
Since the date.
AB 719 is not disposed of.
Not disposed of.
Interim order.
Interim order, my lord.
List again on
26.
Highly obliged.
Having item 35, 36, 37.
May it please your lordship. Lordship, I'm here for the petitioner. Lordship, I was supposed to make one mention early in the morning. However, the crux of the circumstance is that I was also making one mention in court number 13. That is why I could not be here at the same time. My senior, Mr. A. Bhattacharya, he's currently unwell. He's not doing good health. That is why he could not do the hearing today.
You are in item number?
35 and 36, your lordship.
My lord, in item number 35, 36, 37, two ABs are there and one is my lord, this criminal petition for quashing the FIR. Now this case has been succeeded. So any quashing or regarding the consideration of the bail, my lord? Because in those bail petition 36, 37 already interim order is there. So consideration of the my lord, PCR is necessary. At this stage, if you are joining the matter, my lord, kindly call the TCR, my lord.
All the three items arise from same PS case.
case number 132 of 2018.
Already in item 35, you write
One is question,
Learned
other
counsel for the petitioner prays for adjournment on ground of unavailability of learned senior counsel, Mr.
A Bhattacharya.
A.
A Bhattacharya.
A. Bhattacharya. Learned PP submits that since the charge sheet has already been submitted in the case, the scanned copy of the TCR would be necessary. Hence, call for the scanned copy of the TCR in.
in one case it will come, covered other.
No, no,
case.
what is this case number?
Okay, case number, yes, in connection with
Pokradar PS.
Pokradar PS case number 132 of 2018.
From the court of.
Uh,
So it is
Special judge,
Special.
it is under PC Act.
Place the matter again on.
3 weeks.
Special judge court.
Special is Assam. Okay, Gauhati.
From the court of special judge Assam matter. Because
Special judge Assam.
Assam matter, because PC Act is there.
All right. Special judge Assam. List the matter again on.
3 weeks.
Yeah, any day after 3 weeks.
Give a date after 3 weeks. 3rd June.
Lordship, I'm appearing
In
on item number 27. Appearing on behalf of
Item 37. Yeah.
Item 36 and 37, you write in view of orders passed in the connected criminal petition 399 of 2018. List the matter again on. Give the same date.
Lordship, there was an interim in the matter.
Which one?
In item number 35 and 36.
37 also, Lordship.
37 also. In all the cases, you write interim order passed earlier to continue till the next date of listing.
Most of those.
RTH.
Wait, please, your lordship. In this case, your lordship, petitioners have challenged an order dated 16/11/2022, by way of which someone has been issued to them in purported exercise of power under section 319 CRPC. In fact, they were not charge sheeted, but subsequently during trial, in a very casual manner, your lordship, summons has been issued. Before coming to that, your lordship, this case relates to a land dispute initially, your lordship. A fight took place between two groups on 18/7/2012, your lordship. And in that fight, your lordship, two persons died from both the sides. From the petitioner side, 2 persons died, and from the respondent sides also 2 persons died. So on the day of incident itself, on 18/7/2012, an affair was lodged from the petitioner side by his uncle, which is at Annexure 1, page number 12. I have given your lordship. This is Hailakandi PS case number 254 of 2012.
Where is the impugned order?
Impugned order, lordship, at page 44. Before that, your lordship, on what basis the just show the affair that they have lost, your lordship, because we are not charge sheeted in the case initially. So the affair that they have filed on the next day of the incident at page number 19. In our case, affair filed charge sheet, already charge sheeted. Their case also affair filed charge sheeted. In the charge sheet, we are not made accused, your lordship. I have specified there are 4 petitioners here, lordship. Page 19 is the affair, your lordship, filed by the complainant, respondent number 2. Lordship has got the affair at page 19. Two witnesses deposed, nothing special is, nothing said about us as such, our role in this fight, your lordship. And they made a very casual application, petition, which I have also enacted at page 41. And on the basis of that petition, your lordship, someone has been issued in a very casual manner. While lordship knows that section 319 CRPC is a special power, your lordship, to be exercised sparingly. and only when sufficient materials come to show that the petitioners are likely to be convicted or to have committed the offense. Page 41 is the petition on the basis of which the impugned order was passed.
Yes. So what is the evidence?
Evidence also I have annexed your lordship at page 33 and page 37. Before that, whether lordship will go through the FIR. Because initially they have lodged an FIR, your lordship. They are regarding our involvement, nothing special as such was said.
But you were named.
Named, but no involvement was shown, nothing was shown. The persons against whom
That's
directly.
okay.
Yes.
319 court is supposed to act on the evidence, not on the FIR.
Because charge sheet was filed way back in 2013. Since then, they have not also filed any objection against that, your lordship, or any.
What does it matter as far as 319 is concerned? Whether they filed objection or not?
No, that is correct, your lordship, but there should be some materials which shows that we have committed the offense, your lordship. Only because some witnesses say our name, that is not enough. That is what the.
What is enough?
Some materials which shows that we have committed the offense.
What material will be there other than the evidence of witnesses?
Yes, no, even in evidence also, your lordship, they must say what they have stated in the FIR, that is, they have stated. Evidence lordship will find at page 33.
What is your name? How many petitioners?
4 petitioners, your lordship. Lordship may kindly note down
You
the
are?
names. For Anwar Hussain Chaudhary.
Anwar.
Then Abdul Sukur Majumdar. Sukur Majumdar. Then Isfaq Hussain Chaudhary. Isfaq.
Abdul Majumdar.
Sukur. Abdul Sukur Majumdar.
Then
third one is Isfaq Hussain Chaudhary. ISFAQ. Isfaq Hussain Chaudhary. And the fourth one is Taj Hussain Chaudhary.
yes. Taj Hussain or Taj Uddin?
Taj Hussain, your lordship. There are many persons here.
Same person.
I'll just check the father's name. No, Taj, same person. Ataur Rahman Chaudhary. FL lordship will get it page number 19.
Taj Chaudhary and Tajuddin Chaudhary probably same person.
Same thing. Father's name is same.
What more is required? Both the witnesses have stated the other accused persons also assaulted my husband, brother-in-law with sticks and lengza in their hands. Accused Ishfaq Hussain, Anwar Hussain Chaudhary, Anwar Hussain Loskar, Abdul Sukur also assaulted my husband Abdul Mannan, etc., etc. What more is required?
No, Lordship. In the FIR, if Lordship has gone through, they have given the specific who have done what, your Lordship.
You're
Absolute-
part of it.
and nothing has been mentioned. that we are-
34 is there.
Nothing has been mentioned, your Lordship. There was a group fight between two parties, two persons from our side died, two persons from their side. So we have also filed an FIR, they have filed an FIR. Large number of people have been made FIR named accused. But after investigation, your Lordship, charge sheet has been filed against those accused who have been found to have been committed. They are, your Lordship, charge sheet in 2013. Now only this is that whatever in the FIR that they also assaulted my husband. In fact, the PW1, she has not said anything as such. Only the other accused person has also taken part, your Lordship. And the petition, Lordship, will see how they have filed the petition, your Lordship. Because the witness will say that he has also participated, so I should also face the trial. That is not, your Lordship, the import of section 319.
Of course, if you have participated, will be roped in under section 34.
Yes,
Then
it is their Lordship, but not that only somebody if suddenly come and say.
joint liability.
Who have given the fatal blow and what are these things that is specifically stated, your
Even
Lordship.
in the FIR, you have been named and they have taken specifically the names of some persons and the remaining as other persons, other accused persons. So what is the difficulty with that? An FIR is not a charge sheet.
Never. Correct, your Lordship. But what section 319 says, your Lordship? That where in the course of any inquiry into any trial or an offense, it appears from the evidence that any person not being the accused has committed any offense for which such person could be tried together
Yes.
with the accused.
Yes.
Only because
What
they
is the
have come and
difficulty in
said
trying
that
them together is the same incident.
same incident, your Lordship.
Yes.
Now they have named FIR named, they have specifically stated who have done what, and then in the FIR they have given a long list of as many as 16 persons, your Lordship. Now, while charge sheet has been filed, your Lordship, those persons who have been found to have police, whatever they have found, they have given a charge sheet, your Lordship, who have not been charge sheeted, your Lordship. Now, your Lordship, in 2013, the charge sheet has been filed. Now, during the trial, the evidence, one of the witness comes and says that other persons have also taken part, your Lordship. Is that sufficient to rope me
That
in?
is the purpose of 219. When in the course of the trial, it appears someone else is involved.
No, it
That
appears
is
from
to
the
be roped in.
there must
And
be,
here in the course of the trial, they have specifically
must be some
stated your names.
apart from giving my name, they have not said anything, your Lordship, that they have also taken part. That is also
They have
there.
said they specifically they have taken part. Other accused persons assaulted my so and so. So
PW1, she has not said anything. PW2 have
one is enough.
further improved, your Lordship, and she said that we have also
Two
taken.
is enough. We are not to here to appreciate the inter se
No,
evidence
correct,
now.
your Lordship, but
Only
whether
thing
there
is if the material
efficient-
has come out.
whether that is sufficient for us to face the trial, your Lordship, of a murder case, your Lordship.
Yes.
That is the question, your Lordship. In this regard, I'll just rely on one judgment of
Question is
some.
also, how can you be allowed to go when you have been specifically named?
In the affair, your Lordship, they have not said anything specific about us. Only our name has been mentioned in the affair.
It is not necessary to say everything specifically.
Yet, your Lordship, since it is a murder case, your Lordship, some reference that we have taken part or something, even that is also
You
not
have
very.
been named and then it is said that the accused persons did such and such things. So
One judgment, I will rely, your Lordship. Section 319 has suffered the scrutiny of the apex court and this court also, your Lordship. This is 2017 7 SCC 706, your lordship. And rely on paragraph number 12, your lordship. Paragraph 12, but page number. Lordship has got paragraph number 12. The moot question, however, is the degree of satisfaction that is required for invoking the powers under section 319 CRPC. And the related question is as to in what situation this power should be exercised in respect of a person named in the FIR but not charge sheeted. These two aspects were specifically dealt with by the Constitution Bench in Hardeep Singh case and answered in the following manner. At the time of taking cognizance, the court has to see whether a prima facie case is made out to proceed against the accused. Under section 319 CRPC, though the test of prima facie case is the same, the degree of satisfaction that is required is much stricter. A two-judge bench of this court in Vikas versus State of Rajasthan held that on the objective satisfaction of the court, a person may be arrested or summoned as the circumstances of the case may require. If it appears from the evidence that any such person not being the accused has committed an offense for which such person could be tried together with the already arranged accused persons. Now, power under section 319 CRPC is a discretionary and an extraordinary power. It is to be exercised sparingly and only in those cases where the circumstances of the case so warrant. It is not to be exercised because the magistrate or the session judge is of the opinion that some other person may also be guilty of committing that offense, only where strong and cogent evidence occurs against a person from the evidence laid before the court that such power should be exercised and not in a casual and cavalier manner. Thus, we hold that though only a prima facie case is to be established from the evidence laid before the court, not necessarily tested on the anvil of cross-examination, it requires much stronger evidence than mere probability of its complicity. The test that has to be applied is one which is more than prima facie case as exercised at the time of framing of charge, but short of satisfaction to an extent that the evidence, if goes unrebutted, would lead to conviction. In the absence of such satisfaction, the court should refrain from exercising power under section 319 CRPC. In section 319 CRPC, the purpose of providing if it appears from the evidence that any person not being the accused has committed any offense is clear from the words for which such person could be tried together with the accused. The words used are not for which such person could be convicted. There is therefore no scope for the court acting under section 319 CRPC to form an opinion as to the guilt of the accused.
That is the precise judgment which the trial court has relied upon.
Yes, they have relied upon in this court, but what the court says, it is not that only prima facie case. Yes, they have named me, there is a prima facie case against me, correct? That I was, but this is only a prima facie case, Your Lordship. But exercising of power under section 319 CRPC when we have not been charged sheeted, Your Lordship, this prima facie case will not do, Your Lordship.
Whereas it said that if you are not charge sheeted, you cannot be arraigned under 319. It only says, talks about the degree of satisfaction.
Degree of satisfaction, Your
And
Lordship.
that is a subjective matter.
Moving forward, Your Lordship, in order to answer the question, some of the principles enunciated in Hardeep Singh case may be recapitulated. Power under section 319 CRPC can be exercised by the trial court at any stage during the trial, that is before the conclusion of trial, to summon any person as an accused and face the trial in the ongoing case. Once the trial court finds that there is some evidence against such a person on the basis of which evidence it can be gathered that he appears to be guilty of the offense. The evidence herein means the material that is brought before the court during the trial. Insofar as the material evidence collected by IO at the stage of inquiry is concerned, it can be utilized for corroboration and to support the evidence recorded by the court to invoke the power under section 319 CRPC. No doubt, such evidence that has surfaced in examination chief without cross-examination witness can also be taken into consideration. However, since it is a discretionary power given to the court under section 319 CRPC and is also an extraordinary one, same has to be exercised sparingly and only in those cases where the circumstances of the case so warrant. The degree of satisfaction is more than the degree which is warranted at the time of framing of charges against others in respect of whom charge sheet was filed. Only where strong and cogent evidence occurs against a person from the evidence laid before the court that such power should be exercised. It is not to be exercised in a casual or cavalier manner. The prima facie opinion which is to be formed requires a stronger evidence than mere probability of his complicity. When we translate the aforesaid principles with their application.
So what is strong and more cogent evidence than the account of the eyewitness?
No, she is the complainant, Your Lordship.
Is the eyewitness also?
That is correct, Your Lordship. She has not been tested on the basis of cross-examination, whether she was actually there or not. But she only says that
So
we are
we have
also
to
present.
presume she was there. At this stage, we have to presume she was there. Supreme Court has said that cross-examination is not necessary.
Not necessary, your lordship. But
Hmm.
from the
So
evidence
what could
that
be more cogent evidence than the testimony of the eyewitness?
that has
before the
surfaced,
court
your
on oath?
lordship, is only a prima facie case that has been made up, that we are also present there.
These are all words to be bandied about. You can say it's prima facie, other side can say it's more than that. So everything depends on the facts of the case. These are general propositions. Anyway, go on.
Yes. Now, when we translate the aforesaid principle with their application of the facts and case, we gather an impression that the trial court acted in a cavalier manner in passing the summoning order against the appellants. The appellants were named in the FIR. Investigation was carried out by the police on the basis of material collected during the investigation, which has been referred to us by Awas. I found that these persons, appellants, were in Jaipur city when the incident took place in Kannur at a distance of so and so. The complainant and others who supported the version of the FIR regarding arrest present of the appellants at the place had also made statements under section 161 CRPC to the same effect. So court has also considered the statement under section 161 CRPC and then has come to a conclusion, because I'll now read the concluding paragraph, the lordship, paragraph 15. This record was before the trial court. Notwithstanding the same, the trial court went by the deposition of the complainant and some other persons in their examination in chief with no other materials to support their so-called verbal or ocular version. Thus, the evidence recorded during trial was nothing more than the statements which were already there under section 161 CRPC recorded at the time of investigation case. No doubt, the trial court would be competent to exercise power even on the basis of such statement recorded before it in examination chief. However, in a case like the present, where a plethora of evidence was collected by the AO during the investigation which suggested otherwise, the trial court was at least duty bound to look into the same while framing prima facie opinion and to see as to whether such stronger evidence than mere probability of their complicity has come on record. There is no satisfaction of this nature.
This is entirely on the facts of that case.
Correct, your lordship. So in our case also, only they have made the statements, your lordship. Nothing, because had it been that she has made a fatal statement that I know I made a particular blow, that is different. We are also present. We also took part in the fight, your lordship. It was a fight between two groups, your lordship. We have also two persons died from our side, two persons died from their side.
You are not denying your presence.
I am denying, your lordship.
Where?
No, not so, your lordship.
You see, you keep saying it was a fight between two groups.
Yes,
Meaning
yes.
you were in the group itself.
No, we may be there, your lordship.
Then
But
you
that-
are not denying.
That does not mean that we have taken part, your lordship.
That is, of course, a matter of trial, but this
From-
stage,
From this, your lordship,
CD is there.
My lord, the entire LCR was called for, my lord, LCR was sent, my lord. Although, my lord, the LCR was not called for, my lord. Only the second copy of the trial court record was called for, my lord. But if lordship will find, my lord, the order dated, might order dated 27 to.
TCR, I think.
No, not TCR, my lord. Yes, the trial court
TCR.
TCR, my lord. TCR has been sent for, my lord. Although, my lord, it was not, my lord, called for, my lord. Because it will amount to stay of the proceeding, my lord.
Yes.
So on 27 to 2023, my lord, second copy was called for, my lord. Thereafter, when the matter was last listed on 7 to 2026, my lord, one of our colleagues said, my lord, it is not up to date, my lord, the second copy, my lord. Then, my lord, the TCR was called for, my lord.
TCR was sent only on last month.
But, my lord, they have not appeared before the trial court. They have stated that we have filed a revision. So, my lord, the time may be granted for their appearance, my lord.
Of course, since the TCR is here,
Lordship can
effectively
dispose of-
trial is stayed.
Yes, my lord.
No, it is, I think this scan copy of the TCR is here.
No. It's
No,
original-
these are original records.
original is here.
records.
So you go through it.
I have gone through, my lord.
Huh?
I have gone through, my lord.
You have gone through 161 statements.
On a 6 statement, my lord, also the, my lord, evidence of the PW 1 and 2, my lord. So, my lord, from the evidence, lordship has also gone through, my lord. So, evidence is clear, my lord. Now, my lord, they have filed this application, my lord, under section 397 CRPC, my lord. So, what does, my lord, 397 CRPC says, my lord? Calling for records to exercise the power of revision, my lord. The High Court or any session judge may call for or examine the record of any proceeding before the any inferior criminal courts situated within its or his local jurisdiction for the purpose of satisfying itself or himself as to
the correctness, legality, or propriety of the finding, sentence, or order, recorded or passed, and as to the regularity of any proceeding of such inferior court, and may, when calling for such record, direct that execution of any sentence or order be suspended, and if the accused is in confinement, that he be released on bail on his own bond pending the examination of the record, my lord. Now, my lord, the revisional power of this honorable court is, my lord, limited, my lord. Lordship will have to say, my lord, what is the irregularity committed by the trial court while passing the impugn order, my lord. Now, my lord, admittedly, my lord, an application was filed, my lord, after recording the evidence of PW2, my lord. Now, my lord, what the trial court, my lord, come to the conclusion, my lord, while passing this order, my lord. Lordship may directly come to, my lord, page number 47 of the, my lord, criminal revision petition, my lord.
Order of the magistrate.
Order of the petition, my lord, I am not going to the entire order, my lord. Yes. Only, my lord, from page number 47, my lord. The provision of section 319 CRPC and the explanation given by the Honorable Supreme Court of India in the above referred case makes it clear that the, my lord, learned trial court had referred to, my lord, Ramesh Chandra Srivastava's state of Uttar Pradesh, my lord. And, my lord, on the basis of that order, my lord, the trial court came to the conclusion, my lord, that referred case make it clear that a person can be called upon to face trial if it appears to the court that there are strong incriminating materials against him. Summoning a person as an accused to face the trial does not necessarily mean his conviction. In the case in hand, the names of persons mentioned in the petitions were cited as accused in the Azahar filed by the complainant Humaira Begum Borbia PW1. The person in her evidence also implicated all accused persons as named in the Azahar. Similarly, PW2 Ms. Mariam Begum Borbia also implicated all the accused persons, including those who were not sent up for trial. I find that there are strong materials to invoke the power contemplated in section 319 CRPC. Accordingly said, my lord, so and so, my lord, be treated as an as accused person in the instant case, issue summon to them for their appearance on the next date, my lord. What is the wrong committed by the trial court, my lord? After recording the evidence of two PW witnesses, admittedly who are the eyewitnesses, my lord, the trial court came to the conclusion that, my lord, there are prima facie materials also available, my lord, against these two persons. And by exercising, my lord, the power conferred under our section 319 CRPC, my lord, that I am reading again, my lord, where in course of any inquiry into or trial of an offense, it appears from the evidence that any person not being the accused has committed any offense for which such person could be tried together with the accused, the court may proceed against such person for the offense which he appears to have committed. So, my lord, learned trial court, my lord, after going to the evidence of the, my lord, PW1 and 2, my lord, and considering the, my lord, the application filed by the, my lord, informant, my lord, the trial court has passed this order, my lord. So there is no irregularity, my lord, in passing this order, my lord. Hence, my lord, the revision, my lord, devoids any merits, my lord, that may be, my lord, rejected, my lord.
Yes, petitioner, anything more?
My lord, in this case, my lord, I beg to rely on the two, my lord, one case, my lord, Bhardeep Singh, my lord, 2014 2 SCC criminal 86, my lord.
I think both sides are relying on it.
They are not relying, my lord, because it will go against them, my lord.
Hardeep Singh is there, it is the main case.
Bhardeep Singh, my lord, I am relying Bhardeep Singh, my lord. Power to proceed against the other accused persons appearing to be guilty of offence. Court has ample power under section 3191 of the CRPC to take cognizance of any offence against the person who has not been named in the search sheet. If during inquiry or trial, this person's evidence against such persons to be involved in the occurrence and that where the investigation agency for any reason does not array any of the real culprit as an accused, the court is not powerless to calling the said accused to face trial. Ma'am. Just লিখিত হৈছে ওচৰত। যদি ইমান চান ল'ব টাইম দিব নোৱাৰো।
Resolve. Lordship, in this paragraph 15, what the court has said, that mere complicity, some evidence that yes, they may be also be part in the crime. There is not sufficient, your lordship. The court has to form an opinion which is more than prima facie. Though it is subjective, but it also clearly hints that only because one witness comes and names, because they are FIR named accused, but they have not been charge sheeted, your lordship. After an investigation, I have also given both the affairs. There was a fight, 2 persons from our side also died, from their side also died. In our case also, some persons were, though FIR named, but police has not charge sheeted. And in their case also, though some people are FIR named, but police have not charge sheeted, because both the cases are togetherly investigated and then charge sheets are filed, your lordship. So lordship will see on the basis of the record whether the evidence that has been tendered, it is sufficient for invoking the power to face them trial under section 302 CRPC, your lordship. Calling a witness is very evidence, but it is very difficult to face a trial, your lordship. So if there is sufficient material, your lordship, it's not that they should be roped in. But if only because they have stated that no, they are also present and they have taken what, that is not sufficient, your lordship. That's what the Supreme Court says. Because this is a discretionary power that has to be exercised on the basis of not only prima facie evidence, more than prima facie. That is what they say.
But less than conviction.
Maybe less than conviction, but it shows that yes, they have committed the crime.
Yes, CAV.
39.
Lordship, I am petitioner in person, Lordship.
When I just cite if your lordship can verify.
Made please your Lordship. Lordship, I am petitioner in person and conducting the case. The present petition is filed. Seeking direction, seeking challenge to the FIR, which is at page number 17. Millet. Am I audible, Millet?
Is he in this case?
Yes, Lordship.
Yes, okay. Yes.
Yeah, Lordship, a present petition, criminal petition has been filed seeking quashment of FIR, that is under section 376 IPC and 67 of IT equivalents. What happened in this case, Millet? The FIR was lodged on behalf of one lady, Millets, and the FIR is at page number 17. May it please your Lordship? Lordship, may I read?
Yes, yes.
Lordship, page number 17. It is a humble request that party so and so who is working as a primary teacher in Arunachal Pradesh. Chandan Pathak, son of so-and-so, that is me, my lord, petitioner. Village so-and-so, district so-and-so, and resident of so-and-so, who is working in Balrampur as an assistant engineer, who has made friendship with me through Facebook, then made my nude photos, videos through video call, and started blackmailing continuously through phone calls and demanded 5 lakh and called me to the hotel on pretext of taking money from me and raped me forcefully by mixing some drugs in my coffee. And when when at that time I tried to protest against it and tried to call the police, he broke my phone calls and also tried to kill me by strangulating me. And when I became unconscious, he made my video again. And by this way, he had made physical relations with me multiple times. And then I had to file an FIR. He said that I will marry you. And he also made me talk to his parents and started coming to me from Balrampur and also put vermilion on my forehead and created a false scene of marrying me. And that vermilion was from Kamakhya temple. When I asked to take me to his home and marry me, he threatened to kill me and said that I will post your nude video on YouTube and Facebook. I will give and will kill you also. Therefore, it is requested that strict action may be taken against him. So, Lordship, gist of the allegation is, my lord, that I have made some nude video during a phone call, which allegedly was recorded by me. And thereafter, I started blackmailing her on that pretext and demanded 5 lakhs as a ransom, my lords. And thereafter, I called her to take that money in a hotel, where in mixing some substance in the coffee, I forcibly raped her. And thereafter, when she tried to call police, I forwarded one pretext of marriage, and on the basis of which she became a consenting partner thereafter, and meeting me multiple times, and my talking with my parents multiple times. And thereafter, when she said once time that go take me as my wife to my home, I denied that and also said that I will upload your nude video and photos and I will kill you. So, my lord, my simple submission, my lord, is this, that even if prima facie, my lord, submission taken as entirely true, my lords, the entire allegation is revolving around a nude video, my lord. And after investigation, kindly see, my lord, which is at page number, my lord, charge sheet. Page number 138, started from page number 138, runs to 148, my lords. Nowhere in the charge sheet, my lords, investigating officer found any such material, my lord. Entire absence. My mobile phone was seized and it was investigated, and thereafter he filed that no such recovery was there. So, my lord, prima facie, entire allegation which is founded on that nude video is prima facie, my lord, frivolous and vexatious, and it is only, my lord, to spite personal spite, my lord, and nothing else, my lord. Even otherwise, my lord, my second submission is, my lord, that even if it is true, that entire allegation, let's say, my lord, this is true, then even thereafter, after investigation, my lord, nothing is there, my lord. In form of search and seizure, you will just see, my lord, that one hotel bill and register, that is why page number 151 to 165, which has been annexed along with charge sheet by the IU, my lord. There, what he submits, that lady came one day before when I reached the station, and lady gone one day after when I left the station. So he came one day earlier and go one day after, but nowhere in the witness statement, that is hotel witness statement, my lords, which is as page number 145 in the charge sheet, nowhere it is written, nowhere it is stated by any witness that any such hue, cry or protest or anything, my lord. Nothing sort of anything, my lord. No material at all, my lord. And simple, my lord, they saying that she came one day earlier. They remained after 5 days in the hotel, and she left one day after the guy left from this station. So, my lord, my simple submission is that he, in the Bhajan Lal's case, that is point number 3, point number 5, and point number 7, is strictly falling in these 3 categories. My case, my lord. Hence, I pray this lordship that kindly quash this entire petition because even it is my lord fundamental material is not there. Kindly lordship अगर 161 आप देखेंगे 161 that is my lord as 117 page number 117 may I read my lord?
117.
Yes.
Yes.
Here it is very valid. Reading valid. My name is so and so, address so and so, in Arunachal Bharu, middle school for 4 years. Years ago, I got to know a boy by name so and so. So, located at Paltan Bazaar, Trisuya from 15 to less incident to 20. Once a year, the station. During my stay in that hotel, the said boy married me by putting vermilion on my forehead and indulged in sexual intercourse with me. And I told him that I would lodge a complaint against over that matter by going to my mobile phone and assaulted him. I wanted sister-in-law and friend of so and so persuaded me not to file complaint for 10 days and therefore my lodging of complaint is delayed. So here my entire different story. वहाँ ये कहा जा रहा है मैं सबमिट some part in हिंदी also. वहाँ ये कहा जा रहा है कि पहले मैंने ब्लैक
Want to check code, yeah. Just a moment, your voice is very breaking down. Just wait for a while.
fire. The version is that there I blackmailed and then I promised a marriage and on that with me and then here my lord, even in 164 my lord, is totally different. So comparison of my lord, kindly see two statements that so lordship will compare these statements. It's totally different. My lord. Even entire initiation of a story and in between, entire thing is different. और चार्जशीट मतलब that mallet 145 5 married mallet
Yes.
that's a one page the statement of informant which has been investigated by the as disclosed after investigation. I'm reading that mallet from first side. The contact with
What are you reading?
engineer through Facebook.
Which page are you reading?
45
145.
internal page 145. So from top mallet first line came into contact with forged nude photograph of her and threatened her to photograph in the internet and also demanded 5 lakhs from her. Located in Paltan Bazaar and after reaching the accused administered analgesic illicit items in coffee and multiple times committed rape upon her. When she resisted, it damaged her to mobile handset and tried to kill her. So this is the gist of government suicide investigated by the IO. Now, kindly come to the finding. As per statement, so came to voter on 15 to 2023. At first, in 2023, around 1 p.m. the lady so came and booked room in her and Chandan Pathak's name. That is me, my lord. Chandan Pathak came to hotel same day at around 9:45 p.m. They introduced themselves as married couple. They both stay in the hotel from 15/2/2023 to 19/2/2023. Chandan Pathak left the hotel at 19/2/23 and Pooja Upadhyay, sorry, Malat. And the lady left hotel on 20/2/2023. Hotel bill is made in both the guest name. So IO concluded, Malat, that at the relevant time, the incident time, I was not there at the station at 9:45 p.m. If you see, Malat, kindly cover page of the FIR. That is, Malat, at page number 17. What is the timing of FIR? Lordship, page number 18, that is the cover page of FIR book. So, section 3, subclause B, that is, my lord, occurrence of offense. Day is Wednesday. Date is 15/2/2023. And time is 1 to 9 p.m. Kindly note it, my lord. I was not there at the station at the relevant time. And I was falsely briqueted. On the delay part, my lord, 17 days delay happened in lodging the FIR. And she is saying that because some marriage deal was there going on, and that has failed, leading to registration of this FIR. So, my lord, is clear cut, my lord, vendetta.
Yes.
I have also annexed judgment, my lord. Kindly, Lordship, I want to some legal submission forward. So I want to forward some legal submission that in substance, after reading of the allegations in FIR, it is, my lord, the second part, first part, that is against her will, that is forcible rape, as per section 375 IPC, my lord. But, my lord, in 161, kindly see, no whisper of any forcible rape is there, my lord. Story around revolving around some marriage and uske baad some physical relationship and then 10 days dealing with marriage prospect, and when it got failed, FIR lost. That was the delay for 17 days. But 10 days, my lord, explained, 7 days not explained. And even in 164, kindly see the initiation proportion. Here in FIR, it starts from nude video, then, my lord, calling to hotel, and then administration of drugs, or there that portion is completely missing. Video is there, but by reaching the hotel, she is saying that no, some altercation was there, no administration of drugs, nothing else. So it's a clear cut case, my lord. I am just requesting your lordship, that is bare perusal of 161 and 164 and comparison of those statements, my lord. It's clear cut case of, my lord, false implication. And I'm relying on page number 96, my lord. My petition that I have annexed one judgment of the Honorable Supreme Court. If the lordships will consider, page number 96, my lord.
Dilip Singh.
Yes, sir. Yes, lordship. That is the clear judgment about against her will concept, my lord. That when and how that against her will come in operation, my lord. So here para 12 is a very relevant portion, my lord. Dilip Singh case, whether, however, it was also factually similar case because both were adult, both were in a adult relationship, and anyhow the girl got pregnant here, and when the marriage prospect failed, lordship, I will submit, lordship, but kindly allow me to read just only para 12, my lord. I will submit. So, my lord, kindly para 12, whether accused guilty under first clause of section 375. The next question is whether the appellant had sexual intercourse with the victim girl against her will. White clause section, first clause of section 375. The expression against the will seems to connote that offending act was done despite resistance and opposition of the woman. On this aspect, the trial court did believe the person of the informant victim without much of discussion. In reaching this factual finding, the trial court failed to analyze and evaluate the evidence which was given before the trial court. In this case, the victim girl, the High Court merely affirmed the trial court's finding on this point. We should therefore scrutinize her evidence and examine whether it would beyond any reasonable doubt lead to conclusion of the accused having had any sexual contact against her will. Though in the FIR, in this case FIR में ऐसा कोई नहीं था against her will. It was false promise of marriage. But subsequently before the trial court, the girl admitted, girl specifically stated that it was first encounter was against her will, but later on I became consenting partner on the promise of marriage. So Honorable Supreme Court specifically examined the first and second incident, Malad. First incident is, though in the FIR, the version of forcible sexual intercourse has not been put forward in the deposition before the court, PW2 tried to build up this plea. According to PW12, the first act of rape took place in the wheat field of the father. This is how she described the incident before the trial court. In the field, once getting a chance, Dilip Singh forcibly raped me. Dilip Singh told, "Will you marry me?" When I was weeping. He said, "Weeping is useless and we shall marry." He promised me of marriage and raped me several times thereafter. She then stated that after she became pregnant, she revealed to her mother about the rape. Later on, the accused became ready to marry her, but his father and others took him away from the village. She also stated that the accused time and again told her that they will have a court marriage also. In substance, now a very relevant portion. In substance, what she deposed was the first sexual intercourse took place against her will, though she became a consenting party later on. So this was the ballot culled out from the facts deposed before the trial court and in the ballot FIR, that in substance the first action as alleged by the prosecutrix was against her will, but secondly, after some time when some marriage prospect was there, she became a consenting party later on. So at last as page number 97, kindly see next page, that is highlighted portion. So here very description of the judgment. Now is a operating portion. In any case, if the rape was committed by the accused much against her will, she would not have volunteered to submit to his wish subsequent to the alleged first incident of rape. She admitted that accused used to talk to her for hours together, and that was within the knowledge of her parents and brother. This statement also cast an element of doubt on her version that she was subjected to any sexual intercourse in spite of her resistance. So, Honorable Supreme Court, my humble submission, is that if the first encounter was very well against you, against your will, in spite of your hue and cry and resistance, then you cannot be succumbed to the subsequent wishes of the perpetrator. So here, my lord, inherently improbable allegation in the FIR itself. In first para, she is saying that I was a blackmailer come rapist, my lord. And thereafter, in second para, what is saying, my lord, I advanced some prospect of marriage, and thereafter she started meeting with me, my parents, talking about marriage. And when this proposition got filled, then thereafter it was lodged, my lord, FIR. So both the paras, the second para and the first para, before the alleged incident committed, my lord, this cannot coexist, my lord. Mutually exclusive events, my lord. In normal course of event, this cannot happen at all. She's an adult lady, my lord, 32, I am 26. Nothing is on record. Charge sheet, kindly peruse charge sheet, my lord. It's a mechanical subjection to the trial court. You just go and face the inquiry and trial. Nothing is there. It's a mechanical prosecution, my lord.
Yes.
And second thing, my lord, I want to also rely upon page number 99, my lord. I will submit these judgments also, my lord. Para 15, page number 19. The highlighted portion, it was also a case of, my lord, young lady that is age of 30. And there was some relationship, adult relationship between them. And this was also about the hotel prospect. Matlab ki hotel, she came first day and thereafter 1 day left after, nothing has been said, nothing has been deposed, anything. Matlab. So here says, while coming out the hotel room, the prosecutrix did not raise any protest, did not make any hue and cry, or did not complain. She signed hotel register while leaving the hotel with appellant. Lastly, while entering the hotel, the appellant accused and the prosecutrix posed as husband and wife. This is the case, my lord, here. IO is submitting and the statement of witnesses is showing that she came 1 day earlier and deposed that I am wife of him and he is coming. And thereafter I came on 15th and she stayed after the alleged incident for 6 days in the hotel. She left 1 day after, but nothing has been said to the hotel witness or even 100 yards police station. My lord. And 17 days after, my lord, this cooked up allegation came when the prospect of marriage was failed. So this is a clear case, my lord, as per my understanding, what I have understand, that it is a clear case of false implication, bad motive, and my lord, vexatious proceeding. And otherwise, if this prosecution will go on, my lord, this is mechanical prosecution, because nothing is there to establish any fact. That's why 67 IT Act has been deleted by the investigating officer in the police report, my lord. The very basis of the prosecution. Even, my lord, medical examination denied. Nothing is there. No recovery, no forensic material. 161, 164, totally diametrically opposite. In one, she is saying that we have some marriage and thereafter some relationship made, and thereafter I threatened her to complain. And he said that 10 days time will be given. And in this 164, she is saying that there was a video. He called me hotel, and thereafter some altercation, fight was there, and thereafter she started raping me. Or in one FIR, totally different version. There was a video, called me hotel, and then mixing in drugs in the coffee. I was exploited. So, my lord, my simple submission is that in the FIR itself, if the reading of allegations prima facie, both things cannot happen at the same time. Even inherently improbable and absurd, my lord. No prudent person can ever reach a just conclusion. What has happened? And even, my lord, by going to the allegations, very allegations, if it is true, then, my lord, no evidence is there to even, my lord, establish basic foundational material is not there. So it's a, my lord, clear case abuse of process. One more judgment, my lord, as page number 100 of my petition, that is Deepak Gulati versus State of Haryana, 2013 Supreme Court. Here, my lord, the same story. Two adult persons in a relationship, adulterous relationship, lady gone with the person outside for roaming and roamed about 4 or 5 days, and thereafter she came to the house and alleged the allegation of forcible rape at first incident, and thereafter on the basis of promise of marriage, the same story, my lord, same motive, same story here, same facts. Here at page number, my lord, kindly come page number 102 in Deepak Gulati's conclusion of the Honorable Supreme Court, para 14. The prosecutrix was 19 years of age at the time of incident. This is the finding, my lord. She had inclination towards the appellant and had willingly gone with him to Kurukshetra to get married. The physical relationship established between the parties had clearly developed with the consent of the prosecutrix, as there was neither a case of any resistance, nor had she raised any complaint anywhere at any time, despite the fact she had been living with the appellant for several days and had traveled with him from one place to another. So in the entire Gauhati city from 15 to 2023 and from till 19 to 2023, she roamed in the Gauhati city. On 17th, she went to Kamakhya temple. And, my lord, all the photographs has been annexed in my petition, which the opposite party has not denied. That is, my lord, as 166. They start from 166 and goes to 174. Kindly see the photographs and chats. from 15 to 2023 to my lord, 19 to 2023. She is talking to my younger brother, my lord, in between. And she is saying that I was locked in the hotel room, and thereafter I was being subjected multiple times. And on the other hand, the my lord chats and photographs simply says, my lord, that it is a false prosecution. 166 to 174, my lord. Or she also executed an affidavit in objection to my bail application before the learned sessions judge. That is at page number 126, my lord, where she specifically admitted that at the relevant date, the place of occurrence, I was not present. On 9:30 p.m., I came to Gauhati. And in the FIR, it is specific, my lord, that in 1 to 9 p.m., entire incident happened. And it also has been verified by the IU in the charge sheet as page 145 that I was not at the relevant spot at the relevant time. So it's an undisputed fact, my lord, even from my side and even from prosecution side, that the relevant time I was not there. If I was not there, then entire allegation, my lord, inherently improbable. It means that simply somebody wants to falsely implicate me and punish me. So my lord, simple submission is from the charge sheet and material collected after investigation, prosecution is not able to, my lord, show any material that will be foundational material or even any material that prosecution will even from iota of, my lord, believe that it will even stand at trial.
Yes, let's hear them now. Yes.
That's it.
In the given case, your lordship, if the petitioner is so sure that a case does not stand against him, then let him face the trial. He has already filed a petition for discharge. I am not sure as to the status of it. The court had stayed this proceeding on 12th August 2024, based on the repeated status of which the petitioner has been taking constant adjournments. Let him then compete in the trial through any pleader and prove his innocence. We are not against that. As far as the other things are going, your lordship, then the court may call for the TCR as well as the case diary, and court may see for itself whether such inconsistencies as pointed out by the petitioner are actually there or not.
My lord, I have submitted entire documents and I have also one submitted judgment of the Honorable Supreme Court. If your lordships will consider, it will be very beneficial for me, my lord. Shiv Pratap Singh Rana versus State of MP and other. Dicto case, my lord. Simply, my lord, in this case, what happened that the same story, two adult persons, and one nude video is there, and Honorable Supreme Court has concluded that if the foundational material is absent, the prosecution will not stand at trial and it will be lapsed and collapsed. My lord, this judgment is, I have submitted through one counsel who is representing me in the trial court before your lordship. So, lordship, this judgment may also be considered. And if your lordship consider it necessary, my lord, call for TCR.
Please annex all the 161 statement, charge sheet, everything is here.
Yes, lordship. Everything is there.
Allow some time to go through all the statements and file a written objection in that matter, your lordship. Then lordship will finally dispose of the matter.
It's listed for final hearing.
Lordship. Lordship, one humble submission is also there. Last 3 years, my lord, they have not submitted objection affidavit.
Petitioner was also absent on the last few occasions, so that did not give us an opportunity to do so, your lordship. Lordship may give it the next date for the hearing of the trial is anyway fixed on 30th June. So lordship may fix any date in after 2 weeks.
Where is it pending now?
Before the learned sessions judge, my lord.
What happened to your discharge application?
It is pending, my lord.
It was filed in 2024, but then there was a 3-week stay granted by this court. And taking the excuse of this, the adjournments have been taken throughout, or on that regard, adjournments have been taken throughout till this point, Your Lordship.
Lordship,
It is still at the stage of necessary orders, Your Lordship. Charges have
proceedings,
not been framed. So if at the stage of charge framing, the court would have thought that there were no charges capable of being framed, then the petitioner could have gone out scot-free anyway, but did not
but
pursue.
my lord, my submission is, my lord, that FIR was challenged in 2023. Thereafter, proceeding continued, my lord. Charge sheet was filed. I also, by way of additional affidavit, filed the charge sheet also. So, my lord, my humble submission, and the law is also very clear, my lord,
Why don't
that
you
at the
do one thing then, since your discharge application is pending,
Lordship,
in case that happens to be allowed, then you don't have to urge here.
Lordship,
In
by
case it
one
is not allowed, this is still alive.
Lordship, my humble submission is this, that one judgment I have, today I not have, kindly, maybe some time may be given. That is State of Karnataka versus L. Muniswamy, 1977 Supreme Court full bench, my lord, where the same aspect has been dealt with, my lord.
Because in case this goes against you, then you can
Lordship.
imagine the fate of your discharge application.
Lordship,
The application was filed after filing of this criminal petition.
That is what, so. Better that you.
Lordship, I request that my petition may be decided on merits, my lord.
Yes, that's
Otherwise,
what we can decide on merits. What we are saying, since you are not a lawyer,
Lordship,
in case the High Court holds that is this instant petition is devoid of merit,
Lordship.
what will happen to your discharge application?
Because Lordship, that petition was filed.
Would it stand any chance of being allowed after that?
Lordship, then consequences will follow, my lord. I will then again challenge before the Supreme Court or my lord, Honorable High Court, my lord.
We'll again challenge it before.
Then, my lord, consequences will follow, my lord. If the petition is dismissed, then, my lord, the open remedy open in law, my lord, may be entertained, my lord. If any, my lord.
That will only lie to the High Court first.
Lordship.
And once the High Court's on the basis of the same materials gives a finding.
Then, Lordship, then ultimately course will follow, my lord, then Supreme Court, my lord.
Yes, all right.
Lordship, our play is simple. Since the discharge petition has been pending, there is no stay in the case. If the petitioner had been enjoying a continuous stay of operation of the case, then the present status quo would have been different. Right now, the case is being taken on adjournments based on the fact that this petition is pending here, but this petition is not protecting him per se. The stay has been gone after 3 weeks.
Lordship,
It was passed in 12th August 2024.
Proceeding has.
The discharge petition.
Proceeding has been stayed.
Then if it does not pan out, then
Proceed.
like your lordship suggested, this proceeding stays.
Proceeding has been stayed, my lord, by this honorable court.
No, that was only for
Now,
3
where is the question?
There was no extension of that order.
My lord, until unless, my lord, honorable High Court, honorable this court, my lord, vacate the stay order, it cannot automatically get vacated, my lord. So I request this court, my lord, that some time may be given. So I may place judgment which I have said also, and my lord, my petition may be decided on merits, my lord. Until then, my stay may be 1 month, my lord, as your lordship may deem fit, my lord. 2 weeks or whatever, my lord, time may be appropriate, my lord.
Matter is not going on anyway. What is the point of passing any fresh order?
That's it.
How much time do you want?
Lordship, any time appropriate, my lord, 10 days, 14 days, whatever time, my lord, may be given. So that I can place this judgment also, my lord.
All right, heard learned petitioner in person as well as learned counsel representing the informant. Also heard learned additional PP. prayer has been made by petitioner in person for some time to submit some relevant judgments. Further, Burnett Council representing respondent number 3 also wants to file an objection. Hence, list the matter again on after 2 weeks that.
One small request, my lord, if time, the date may be fixed, my lord.
Yes.
Any date.
We are finding out that date.
19 May. 19 May.
Lots,
19th of May.
lots of. Oblige, lots.
I'm obliged.
Case number 40.
Lots.
What is this? I don't think we have time for that, another hearing. Will be taken up due to paucity of time. List again or give a date.
My pray for date.
Give a date.
Till May. Till May. 18 तारीख.
No, May last. May last.
26 May.
Yes.
Hello.